après cette pause déjeuner, nous reprenons nos travaux avec le contentieux de l'ouverture à la concurrence, donc tant au niveau national qu'au niveau européen. Et je donne tout de suite la présidence à mon collègue Antoine Louvaris, qui va donc animer cet après-midi, avec en tête toujours nos contraintes horaires et l'idée de pouvoir laisser place au débat. Et je vous souhaite donc une bonne après-midi de travail. Merci.
I'm happy and honored to chair this session in the afternoon. I welcome all the participants and especially the speakers who are going to enlighten us on the litigation which this afternoon is dedicated to. That's how life is. No regulation without litigation. And in the final analysis, the judge can appear as a sort of meta-regulator without prejudice to the intervention of non-judicial public institutions, regulatory agencies, the European Commission in the resolution of disputes. I have been entrusted with the delicate task of regulating speaking time, which will be reflected ex ante by a kind reminder to the speakers 15 minutes, and for the duos or duets, 25 minutes in order to allow sufficient time for exchange with the audience. I therefore give the floor to Tony Prosser, Professor of Law at Bristol University, who is the first of our speakers. Thank you very much.
Well, thank you very much, and thanks to everybody for an excellent morning, which I found absolutely fascinating. And let's hope we can continue at that quality. Well, for us from the UK, the heading litigation seems a bit strange because relatively few regulatory disputes actually reach the courts. And it partly reflects the system in which courts are very much a last resort and are very expensive. And also the fact that we don't have a strong historical jurisprudence of public law contracts. And franchises, for example, were treated as private law contracts with their own internal dispute resolution arrangements, which I'll say a bit more about later. There is, of course, a role for judicial review of administrative action, of the regulators, and indeed of the award of franchises. And the most important example was in 2012, when the award of a franchise for the Intercity West Coast line, very important line, was clearly undertaken in a way that was biased against the operator. And as a result, there were threats of judicial review, the action was started, and the award was withdrawn. And that was the beginning of the collapse of the franchising process. But I'm going to deal instead with other institutional mechanisms which are relevant to dispute handling rather than courts. So what are the institutions that might be involved? Well, the General Competition Authorities, the Competition and Markets Authority, that has a role to play. Its predecessor in 2009 undertook a major review of the rolling stock leasing markets through which the operators lease their rolling stock from private ROSCOs, rolling stock companies. It also produced a report in 2016 recommending a major increase in open access to replace franchising on the main lines. But this was not acted on by government and I think has now been largely forgotten. As we heard earlier, the ORR, like other utility regulators, has concurrent powers to enforce general competition law in this sector. And its work has been very, very valuable in this area. And it undertakes market reviews, for example, in relation to the supply of signaling equipment. How competitive is, asking how competitive that is. Okay. Now, we heard this morning also that the ORR is also responsible for taking decisions on open access. I needn't say more on that, given that we have the regulator here. Basically, it applies two tests, the not primarily abstractive test, asking whether the new services would generate new revenue and not take it from existing operators. and a general equilibrium test, which looks at the overall impact of proposals on franchises. What is interesting about that, I think, is that it illustrates the tension between the franchising model and increased competition within the market, and goes some way to explain the limited role of open access in the UK. If the Williams-Shapps reforms are implemented, and I'm pleased to hear this morning that it looks as if perhaps they will be implemented, the ORR will continue its role. There will continue to be independent regulation here. I talked this morning about fragmentation, and inevitably fragmentation and complexity creates the need for a range of different types of dispute resolution mechanism between the different actors within the system. And these mechanisms have not worked well, and the absence of an overall body to coordinate the system was blamed as a major source of problems by the Williams-Shapps white paper. I think I put the quotes up on the slide there, which is very revealing. It referred to this as a costly, inflexible spider's web of often adversarial relationships, penalties, and disconnected incentives, which resulted in a focus on blame rather than seeking sensible solutions. One example is delay attribution, and that's covered by 2 schedules of the Railways Act. And what it involves is where there has been a delay because of something that's gone wrong with the infrastructure operator or infrastructure manager or one operator, which has affected other companies. How do you allocate the cost of that delay? As the white paper noted, this required the use of about 400 full-time staff to work the dispute resolution system, because about 40% of delays were actually contested, which meant that they had to go through this system. There were complex procedures for escalation if a dispute wasn't settled, and a rule book of 199 pages setting out the rules that would be used as the basis for decision-making. It can also result in very strange arcane disputes. Again, this was noted in the white paper. One dispute, I think this was true, was where a train had hit a pheasant, un faisan en français, causing delays to other operators. The question was a pheasant a small bird, which meant that responsibility would lie with the operator, or a large bird, for which responsibility would lie with the network provider? Now, this system was designed to provide incentivization to deal with delays rather than letting them operate. But again, it's adopted a blame focus, limiting cooperation, and the opportunity costs. The costs of actually having the system are very high, contributing to the need for increased support for rail post-privatization. Okay, well, I've been very negative about the UK system today. I'm not actually a negative person, so I don't actually like being negative. So I thought it would be helpful to deal with an aspect of the system which I actually think works very well. And I think it's important because it really emphasizes the central role of independent regulation in opening up financial decisions to outside scrutiny. And this is the role of the ORR in scrutinizing the expenditure requirements of the infrastructure operator, of Network Rail, which are then met partly through access charges, but mainly now through direct grant from the Treasury. Now, this goes way beyond ensuring that charges are not discriminatory. It examines in depth their economy and efficiency, the way that action will be taken by the network operator to ensure that it's economic and efficient. Now, this operates within a framework of a periodic review process every 5 years, the context for which is set by the government issuing what's called a high-level output specification, which sets out the specifications that it will want from the rail network over the next 5 years, and a statement of funds available, setting out the money that the Treasury is prepared to provide to the infrastructure operator. And the role of the ORR will be to assess what can be done with that money to meet those objectives. I think a great virtue of this system is that in principle it should lead to stability for future planning. You have a 5-year framework. Now, I think we have seen important moves towards this. A new high-level output specification was issued December, a couple of months ago, which unfortunately is much vaguer than the earlier ones. Reading through it, it's very short and it has very few clear outputs. But the principle, I think, is still a very good one. The other big advantage is that it provides an opportunity for the regulator to use a highly open, highly participative process to develop a collaborative approach with those involved, with the operating companies and with Network Rail, and to avoid adversary forms of dispute resolution. So I think that it has advantages in providing stability and also in providing the sort of collaborative regulation that I talked about earlier, and I think that's very important. It's interesting, actually, to see that it used to cover enhancements, improvements of the system, but these were taken out of the process in 2018 and instead left for the government itself to issue every year an enhancements pipeline, setting out what enhancements, what improvements would be allowed. Annual updates were promised, but we haven't had one since, I think, 2019. And I think that illustrates both the current lack of clarity in relation to rail policy, and also the fact that if decisions are left to central government, that does not provide the sort of stable expectations for those in the industry, which at best independent regulation can provide. So I think this process illustrates very well the importance of independent regulation. And I think that is one area which the UK has got broadly right. Okay.
Thank you.
Just one final slide for conclusions. The lessons are very similar to those that I stated this morning. When rail was privatized, the assumption was that it was a declining industry that could be made more efficient by economic incentives, fragmentation, and competition for the market. But that fragmentation has meant that there have been highly complex dispute resolution procedures. They've made cooperation difficult and instead have created adversary relationships, which carry considerable opportunity costs. We don't know how this will be resolved in the future, but I'm pleased to hear this morning that it seems very clear that there will continue to be a central role for independent regulation in this. Thank you.
Thank you very much. Thank you. Very interesting. You described the two aspects, the settlement of disputes between the operator and what we would call the budgetary control.
Yes.
And you stressed on the fact that in an efficient regulation, it will be better to be collaborative than...
Yes.
Yes, it's what the character of the litigation. It's not only adversary problems, even in prima facie, it's adversary. Now I give the floor to Paola Chirulli, who is professor of law at the University of Rome.
Thank you very much. Thank you to Aurore and Claudie for the invitation. And thanks to the attendants, especially after the lunch break, so you're enduring the conference. So I'm going straight to my presentation that is on litigation in Italy. Well, the points I'll touch upon very briefly, the first one is regulatory powers with an impact on competition. The second point will be the main focus, the role and the main focus of litigation. The third point will be some reflections on the contribution of litigation to competition and regulation in the sector. Well, let me start with a very, very brief word on the context. We already know quite a lot about it from this morning, fortunately. So the infrastructure and the management system relies on a national infrastructure manager that is a publicly owned company. And also small private infrastructures managers that operate at a local level. So we already know RFI, but also there is the station infrastructure manager that is becoming more and more important from what I will say in the future. So the different patterns of competition, yes, because we know that we have a division between national and regional, and this, of course, makes a difference for regulation and also for litigation. The national is divided up into high speed, but high speed in Italy is also important to people who commute, because we have a lot of people who work in Naples or in Florence or live in Florence or live in Naples and work in Rome, so it's very important. And public service or long distance. Then regional, where we have, roughly speaking, competition for the market. And then the freight sector that is open, liberalized since quite a lot of time. Competition in the passenger rail transport, of course, this is an evolving scenario. Of course, large market share is still in the hands of the incumbent Trenitalia, but we know that there is at least fierce competition by Italo. So in the high-speed sector, we do have relevant competition. The regulatory authority, well, from a strictly legal point of view, it has been given a very broad remit and as a variable geometry set up because it's competent for all basically the different means of transport. There is different relationship between the regulatory authority and the central administration. So actually in the rail sector, the authority quickly acquired a key role due to the concentration of powers, because basically it's the sole regulator and there are virtually no concurrent regulatory powers. So that's why it very actively worked since its establishment and operation in 2014. It has been given extensive powers, regulatory, which are prescriptive, enforcement, investigative, supervisory, complaint handling, so also in the litigation, in dispute settling, inhibitory, provisional, and sanctioning, as well as advisory. So it's a vast array of powers. And also it cooperates with other authorities, such as the competition authority. It signed a memorandum of understanding, but now actually they do have some parallel competencies, but actually the transport authority is very active in the competition field. Very quickly, the most important regulatory measures that are already be touched upon, well, it guarantees the independence of the infrastructure manager, the access to infrastructure, basically the definition of the criteria for the charging schemes, and this is very important, of course. It supervises the network statement, that is the main document that is done by the infrastructure manager, and sets the criteria for the award of regional rail service. Let's go now to litigation. Well, litigation in Italy has a key role, also in this sector. The threat seldom works. So it's very different from what happens in the UK. And we like to go to court, actually. We really, also in public procurement, that's a lot of litigation. Well, the first important role is the need to clarify open-textured legal provisions, so to define and clarify the powers of the regulatory authority. And then there is also this triangle, at least triangle of regulation, because the regulation is often indirect. Basically, the infrastructure manager does a lot of things, and then the regulatory authority supervises and approves of what is done. So there is already a triangular situation, but often even more because, for example, there's Trenitalia watching and Italo as well, or other undertakings. So it's quite a polycentric and at least triangular relationships. And then we have an important need to ensure that there is a full judicial scrutiny of regulatory public powers. This also for constitutional reasons I won't linger on today. Main features of litigation. Who litigates? I've already told you, and I'm not going to tell again, but basically the infrastructure managers and the operators, and the authority, of course. Why? Well, the reasons are basically for the regulatory, the way regulatory powers are or are not exercised, or the way the infrastructure managers writes the concrete scheme for example, the charging or the access to infrastructure or the charges or the markups, etc., etc. Where this is very important because we have a functional competence of the administrative regional court based in Turin, as the authority is. So they both work and litigate in the same place. But this is very important because, as a matter of fact, we have something very similar to a sort of specialized court that I think adds something to the quality of litigation and to the final results. There's also a fast track, but I'll say that after. How? Well, usually what is contested is either procedural points or substantive questions. And the litigation has gone from originally very narrow questions, which were basically on the access to the main infrastructure of this charging scheme, and then has been extending to other previously, but not less important facts, like areas in stations, lounges, publicity, advertisements, etc., etc. So it means that as regulation goes on, also litigation expands. Judicial review, just to have you an idea, actually we have hundreds of cases every year, but these are the cases which are of interest for the rail passenger area and involve the regulatory activity. The other cases mostly deal with fee scheme because the infrastructure managers and the operators have to pay for the maintenance, for the authority, function of the authority, and road concessions and recruitment procedures. But these are the cases, and as you can see, there's been quite a growing, an increase in the number of cases. Let's have a look now at the recurring themes. This is quite interesting. Well, no wonder that conditions of access to infrastructure had played a relevant role in the litigation. Not just of the by the incumbent, but also, for example, obligation of infrastructure managers, private infrastructure managers, to allow access to service facilities when they are essential facilities. And this was justified with competition in general on the rail transport service. Or Trenitalia challenging the regulatory measures which had provided for maintenance spaces, reserving spaces for competing operator without proportion to the passenger traffic, and this action was dismissed. Quite often, regulatory measures are confirmed, but sometimes they are annulled. So usually as in Italy, we have actions for annulment of administrative decisions. Network statements play a very important role, not just in the regulation, but also in the litigation. And here again, we see the indirect remit, because courts deal with the regulatory measures through the filters of the network documents. So both are subject to judicial scrutiny, although the network is technically speaking, would be a private nature document. Access to station and areas and facilities, this is very, very important. A lot of disputes either from Italy, from Trenitalia, about the ticketing spaces, lounges, and information desks. The authority orders Trenitalia to give back the spaces so that the station infrastructure can reallocate them. And in this interesting case, the Council of State is making a distinction between dispute resolution powers and enforcement powers. Sorry, this probably was the administrative court. The Council of State is the appeal on these decisions. Sometimes also independent experts are called by the court, because the court goes sometimes into the review or very delicate technical assessment, and does it with quite an intense level of scrutiny into, for example, the mathematical, the economic methods and models used for assessing criteria or fixing charges or considering cost, direct and indirect cost, the costs a la Ramsey and so on. So there's been quite a lively litigation, and the courts sometimes are differential, but not so often, I should say, because sometimes they are really quite brave into scrutinizing the regulators' decisions. And of course, proportionality of fines, but also perimeter of regulation. Grandi Stazioni, that is the station infrastructure managers, try to say, well, I'm entirely private. Why are you trying to regulate me, and why are we litigating before an administrative court? Of course, his arguments failed, but it was important because the regulatory perimeter and also the perimeter of the subject who are under the jurisdiction of the regulatory authority was clarified. So my final point, because I don't want to run out of my time, the contribution of litigation. Well, I think it's very important for quite a few reasons. Litigation, I want to clarify this, is also disputes before the transport authority. Sometimes they are settled with commitments, and this is also very important, because this means that there is not really negotiation in the negative meaning of the term, but there is dialogue. There is a constructive, proactive dialogue, and this is extremely important. And quite a lot of procedures are closed with commitments before they go to court, or after they've gone to court. A more level playing field for railway undertakings, and this is very important. International operators, for example, were challenging the markups and how the market segment had been identified, and this was very important. And as I said, a quasi-specialized court, a scrutiny also on procedural points, and this is very important. Consultations are important, and sometimes, quite often, procedural question about enough consultation is raised before the court. And so this is very important because this ensures also, let's say, democracy within the way the regulatory process goes on. So regulation by litigation means that through the litigation, there is a process that goes on, and the regulation goes on before the courts and then bounces back to the regulatory body. And this is very important because I think that is really improves the overall quality of regulatory decisions, although it might entail litigation, which, by the way, has a fast track. So usually cases can be decided in both grades, first instance before the Piedmont Administrative Court and then the Council of State in 1.5 years or even less, maybe, depending on the complexity of the litigation. Sometimes the courts are not so nice. Recently there was this determination of the authority, which was very long, and it was about the charges for access to spaces devoted to lounges for passengers, very long And this was challenged by the court, by the operators before the administrative court. And the parties asked for more room to write their documents. And the court said, yes, you deserve that, because there is a pathological length of the decision of the authority. But quite often, those decisions are confirmed. So this is, I think, an evidence that overall the system, I think, works quite well. Thank you very much for your attention.
Dear colleague, for your presentation, noticeably the stress on the scope of the scrutiny of the regulatory body by the judicial power, and on the settlement of disputes as part of the regulatory function. Now I give the floor to Christian Schneider, who is partner of BPV Hügel. Please.
I start my presentation with the question, who is actually the competent regulatory body in Austria and in Germany? Well, in Austria, we actually have two regulatory bodies that are closely linked to each other. We have, on the one hand, Schienenkontrollkommission, and on the other hand, Schienenkontroll GmbH. Schienenkontrollkommission, SCK, as it will be abbreviated in the foregoing. That's a panel consisting of one judge and two further members, and in order to assure independence both from the regulated industry and from the state, the law explicitly excludes highly ranking politicians and market participants from membership, and also guaranteed by law, SCK is freed from instructions by other state bodies, in particular from instructions by the Ministry of Transportation. By contrast, SCG, that's a private limited company in terms of legal form, but the Republic of Austria is a 100% shareholder. How is the repartition of powers between those two bodies? In principle, SCK is competent for all regulatory tasks, namely, in particular, the tasks foreseen by the directive. By contrast, SCG serves as office for SCK, which means that SCK itself does not have any staff. It relies on the staff of SCG, and also the staff of SCG is preparing the decisions by SCK. Apart from that, SCG also fulfills all reporting requirements foreseen by national law and also by the directive, and it further serves as conciliation board for disputes with customers. In my view, by means of that structure, we face some problems. At first place, the independence criteria under Article 55 of the directive do not seem to be fully fulfilled, since, for example, directions by the Ministry of Transportation to SCG are possible, and furthermore, it is not explicitly excluded that staff of the Ministry of Transportation is member of ECG, which means that full independence from other public bodies is, at least not in theory, not fully guaranteed. In Germany, by contrast, we have Bundesnetzagentur, located in Bonn, the former German capital, and Bundesnetzagentur is also competent for other regulated sectors. establishing a regulatory body that is competent for further sectors, other sectors than the railway sector, is explicitly foreseen by the directive. In general, decisions are taken by so-called Beschlusskammern, ruling chambers with 3 members. Regarding independence, it's quite interesting. Other than in Austria, as to ECK, the German law does not explicitly provide for independence of Bundesnetzagentur, and I know there has been an academic discussion regarding independence of Bundesnetzagentur since 15 years ago, but I would say that discussion is academic in nature and does not really affect independence. Well, what are the powers of the regulatory body? In Austria, we have a very general clause. SCK is vested all powers to supervise competition regarding discrimination, distortion of competition, and further adverse development on the market. That wording was included into the Austrian Railway Act some years ago, because originally the powers of the Austrian regulator had been defined very punctually, and there was at least an academic discussion, and I think even a discussion with the European Communion, whether that satisfies the requirements under European law. In conjunction with that general clause, there's also a non-exhaustive list of competencies, for example, deciding disputes on the access to infrastructure and on charges. SCK may act ex officio or upon a complaint by a railway undertaking or another entity entitled to capacity. There's a statutory decision period, 1 month for gathering the relevant information, and then further 6 weeks for taking the decision. Important competencies of the Austrian regulator are, for example, the declaration of access conditions and contractual agreements null and void, and also quite interesting, I don't know how it is in other member states except Germany, in case of a denial of access, the decision by the regulator substitutes for the agreement upon the access. We call that in German Vertragsersetzender Bescheid, or in English, decision in lieu of agreement. The competencies in Germany seem to be quite similar. There's also a general clause. There's a provision saying that all parties entitled to access may submit complaints, and the statutory decision period is the same as in Austria, since it is derived from the directive. Also, important competencies are quite similar, and I would say there's one interesting difference between Austria and Germany. In Germany, you have by far more ex-ante regulation than in Austria relating to charges in particular. In Austria, charges are only subject to an ex-post control, and well, in my view, it is at least, I will not be as apodictic as in the morning, but in my view, it's at least disputable whether that ex-ante control by the regulator is in line with European law. Then, decisions by the regulatory bodies are subject to judicial review. In Austria, they can be appealed before the Bundesverwaltungsgericht, Federal Administrative Court. That's the administrative court in the first instance. That court has the power for full review, with the exception there where discretionary powers of the regulatory authority come into play. There only whether discretion was exercised within the meaning of the law is subject to judicial scrutiny. Complaints have no suspensive effect, but such effect may be granted by the court, and we have a 6-month statutory decision period, but however, in most cases, that deadline is not met. And against the decision of the Federal Administrative Court, you can appeal before the Supreme Administrative Court or the Constitutional Court. In Germany, decisions by BNetzA, Bundesnetzagentur Federal Network Agency, can be appealed before Cologne Administrative Court and further before Oberverwaltungsgericht Münster, which is Superior Administrative Court Münster, and then you can also go to Federal Administrative Court and Federal Constitutional Court. Also here, no suspensive effect, but can be granted, and also full review. But in Germany, there exists the figure of so-called Regulierungsermessen, which means discretionary powers of regulatory authorities. Well, and in practice, what is subject to judicial review, and are there any particularities? Well, I will start with Austria. In Austria, most cases subject to judicial review concern discrimination of Westbahn. As you have heard, that's the private operator in Austria that is very often discriminated against by ÖBB Infrastructure, that's the network operator. And there are manifold cases, maybe a very, very funny one. Some years ago, ÖBB Infra wanted to charge Westbahn for ticket booth in stations a price of 5,000 euro per square meter per month, which even exceeds what you have to pay for a fashion store on Avenue des Champs-Élysées. Other case, Westbahn wanted to send staff in order to assist people with reduced mobility and people who are affected by train delays. So that are things that have to be decided very fastly, and ÖBB Infra wanted them to be notified about that 3 days in advance, giving as reason for that people have to be instructed about the station, and interestingly, the same staff of ÖBB passenger traffic, there was no such notification requirement 3 days in advance. Well, also in Austria, decisions by the regulatory authority and the court can have many pages, not 160 or 600 like in the UK, but there are decisions with 154 pages. That's very common. In Germany, I would say that litigation is very manifold. So I would not focus on particular cases, but I would like to make reference to one very interesting thing at the very end, namely we spoke about fragmentation. If general terms and conditions for the access are subject of review, subject to a complaint, it appears to be practice in Germany that all affected other operators, not only the complainant, are called as party into the proceedings, which in my view is obligatory. In Austria it's not done in that way, but the necessity of that can be inferred from Article 56, para 9 of the directive, which gives to the regulatory decisions a so-called erga omnes effect, because then the decision also have an effect of other complainants, other operators than the complainants. Well, at the very end, a very recent EU law issue I would like to touch, namely whether there are other remedies parallel to that before the regulatory body. There was a German decision saying that besides the decision of the regulatory body, there is no review of infrastructure charges under general civil law. And very recently, in October 2022, the ECJ had to deal with a quite similar question, whether the competencies of the regulatory body exclude intervention by the competition authority. And there, the ECJ said that the powers of competition authorities or of courts dealing with competition law are not excluded by the competencies of the regulatory body, but the other body, the competition body, has to take the decision of the regulatory body into account, but there is no binding effect. So thank you for your attention.
Thank you. Thank you very much for this comprehensive and comparative presentation with concrete cases and the question of the scrutiny and that there may be several competent judges, a specialist judge and a civil judge. It's interesting because we'll see that, like public enforcement and private enforcement in competition law. Now I give the floor to Professor Montero Pascual, who is Professor of Law at the University of Madrid.
Thank you very much. I will start, as my colleagues, with just a few words on the institutional arrangement we have in Spain. Over the last 10 years, since 2013, we've been running an institutional experiment. We merge all the network regulators into one entity. So CNMC, where Ivan works, is in charge of regulation of railways, but also airports, telecommunications, media, energy. And on top of that, they are the competition authority. So that's why we call it sometimes the super regulator, because they have a lot of powers. I think I don't have time to analyze the impact, whether this experiment is successful or not. Maybe that's for another conference. Sorry. But I will go into the details of the kind of conflicts and litigation that we had. And we can say 4 different chapters, the 4 different types of litigation and conflicts. The first one are conflicts, disputes around access to infrastructure, which of course is the main element of the regulatory framework. And here we had a very fundamental dispute between the regulator and the infrastructure manager on what is the parameter of powers of the regulatory authority. And a very fundamental challenge by the infrastructure manager, just as you were referring, to the capacity of the regulator for an ex-ante control of the network statement. Not so much the ex-post review of the track access charges, but the ex-ante control of charges, in particular charges, in the network statement. And there is a very strong position of the infrastructure manager of a refusal to accept the power of the regulatory authority to regulate ex-ante the network statement, up to the point where some decisions have been taken to court, and we are waiting for a decision by the Spanish courts on that point. And I would say this is probably the most fundamental issue of litigation in Spain in the railway industry. Then we have a second chapter of disputes and litigations, which is related, and allow me to devote just a couple of minutes to this, not to the passenger segment, but to the freight segment. Starting around 2015, of course, we had competition in freight before in passengers. So we had a couple of series of cases of complaints by freight operators, by newcomers, but not against the infrastructure manager, which is the most common situation in regulation, but against the incumbent, against Renfe. And here we had 3-4 different cases, which are a little bit exceptional and curious. First of all, on the legal ground that was used by the regulator to step in and intervene, we have a very specific provision in Spanish legislation, which does not exist in the European framework, on the regulation of rolling stock and maintenance facilities. There is a provision in the national legislation which imposes on Renfe the obligation to have subsidiaries, autonomous from the main railway undertaking, that have to provide access to rolling stock and to maintenance facilities under non-discriminatory fair terms. So this is a legal basis that has given the regulatory authority leverage to intervene and to regulate the conditions in which Renfe was providing services to competitors in the freight service. This is quite unique to Spain because we have this provision. So we had a number of cases with regulators step in, intervene, and impose, I would say, even very creative obligations on these Renfe subsidiaries to reduce barriers to entry for newcomers. And these have been taken to court. Some of the obligations have been admitted by courts, others not, and some of them are still pending in courts. And in particular, there is another case in relation with drivers. And again, it's a case not for infrastructure manager, it's a dispute between newcomers to freight services and the incumbent that has a very strong position in relation with drivers. Now, what it is specific to this case is that there is nothing in Spanish legislation specifically devoted to drivers in commercial services, as there is for rolling stock and maintenance facilities. But there is this very unique provision, maybe somehow inspired by some wording in the recast directive that empowers the regulator to intervene to, and let me translate into English a very twisted expression, something like preserve the pluralism in supply. So this is a very vague statement that allows the regulator, gives competence to the regulator to intervene in very broad term. And the regulator has not been shy to make use of this empowerment to step in and regulate. Again, this might be considered as an empowerment to the regulator. But my difficulty, and I just for clarity, a disclaimer, I've been acting as a lawyer in some of these cases. It's not so much about the competence of the CNMC, but about the legal grounds for the specific obligations that are imposed on Renfe. So there is, of course, a basic principle of legality. So if you are going to impose some kind of restriction on an operator, first of all, you have to be competent. Okay, you might be competent, but the obligation itself needs a legal base. And this is a different element. It's not only about the competence, it's about the nature of the obligation and whether there is a legal base for the intervention, for the obligation. But somehow these are all cases. Most of them have been closed, and this is more related to freight. They are interesting probably for a lot of people in the audience, but this is more kind of it's the past. Now, if we move to passengers and we move to the third point, if we move into what has been the liberalization process, this is a Spanish model that we were discussing in the morning, the message is very clear. There has been no litigation. There has been no legal claim against this process, this competitive allocation of capacity, the framework agreement. We made reference, there were 6 applicants, 3 of them got capacity, 3 of them are out of the market, but they did not launch litigation against the decision. So that, I think, it's good news in terms of that the process was clean, was good, and everyone felt that it was fair. There is, of course, and we've heard today, there are some open issues, for instance, on track access charges. Then there is, they are too high, they should be reduced. But there has not been, at this stage at least, disputes, very specific disputes launched by the newcomers to this passenger market, and as far as I know, and definitely it has not been litigation on these issues. I would have a proposition, I don't know, it's an intuition because it's too early to confirm, but my hypothesis would be that when you have a very active infrastructure management, as we had in Spain for this process, first of all, you need also a very active regulator controlling what at the end of the day is the behavior of a monopolist. And we had that in Spain. I mean, we had a very active regulator and Ivan made the reference. There were some proposals by ADIF that were modified in the process. And I think that intergame between an active infrastructure manager pre-arranging and pre-planning market entry with an active involvement of the regulator, making sure that there were no abuses of that monopolistic position, produce a situation where ex post, you don't need a very strong intervention because you have solved many of the disputes before in this pre-planning, pre-arrangement of the market opening. And so far, I would say that has been pretty much the situation in Spain. That's why we are not having, at least at this stage, a lot of disputes. What we have, of course, is when you open the market and you have real competitors, they complain. Mm-hmm. They have interest. Not all their interests are being met. And of course, this creates a lot of activity and a very intense regulatory debate. The infrastructure manager, the regulator. And I think that's happening in a good way. And I tend to think that we are not having more disputes. Maybe it's early because this regulatory dialogue is working. And I have just one example, and maybe it's something that I wonder, and electricity is a big issue right now everywhere with prices increasing. In some of the routes that were liberalized, electricity is a more relevant cost than truck access charges, just so you feel how relevant electricity is. Mm-hmm. And the management of electricity, I mean, the infrastructure manager, the railway undertakings, and a very leading role by the regulator have managed to solve or accommodate the interests of all the parties without the need for disputes or litigation. So I think it's a good example of how this regulatory dialogue is working. I tend to think that over time we will have disputes, we will have litigation, because once you have players, they play, and it's unavoidable. But this strategy to solve problems before they explode, to pre-plan, to pre-arrange, to actively manage, my hypothesis is that it is reducing ex post litigation. Fourth element, very short, ticketing and data. This is a big issue. We have cases, and these are competition law cases. As far as I know, there is an open case in Germany. There was a case in Italy that was closed with commitments, and we have a case before DG Comp, the Commission on Ticketing, with Renfe. Stay tuned, because we might see novelties in the following weeks on this case. And it's data flows, whether newcomers, platforms might have the possibility to have access to the information by the infrastructure manager, but mostly by the railway undertakings, and whether the platforms can display and fully exploit the advantages of digitalization. And there is a very heavy push on railway undertakings, I would say particularly on incumbents, to make their data available. And it is perceived also as a way to make railways more open, competitive, and allow modal shift and multimodality. And I think there is a lot of conflicts and probably litigation around this issue. So these are the 4 chapters, and maybe one final word. You were saying there is no regulation without litigation. Well, maybe in Spain we are having regulation without too many litigation. And the litigation, the lesson is that so far has been focused rather on the powers of the regulator. What is the perimeter of activity for the regulator? I would say not so much on the substance. And litigation has been pretty much limited. And hypothesis, I would say mostly, but it's too early to transform the hypothesis into a law because of this pre-arrangement, this planning that allows through dialogue and the intervention of the regulator to solve the disputes or give solutions before problems explode. So,
thank you very much. Thank you very much for a very interesting presentation, which stresses on the various parameters of the resolution of litigation. the type of power and competence of the regulator, the items of the complaints, what kind of complaint, and the strategy of the litigants and the substantive law which is at stake. So, pour terminer, je laisse la parole à Madame Elisabeth Cotte, qui est directrice juridique de l'ART, qui est l'autorité régulatrice française des transports. Je vous laisse la parole, chère Madame.
Je vous remercie. Bonjour à tous. Si ça ne vous ennuie pas, je vais faire ma présentation en français. Donc, pour ceux qui ont besoin de casque, peut-être je vais vous laisser le temps d'aller en chercher. En tout cas, ça permettra à nos traducteurs de varier les plaisirs. Donc voilà. Alors, je vais vous parler du contentieux de l'ouverture à la concurrence à travers l'exemple français. Et alors, nous, contrairement à l'Espagne, on a pas mal de contentieux. On a un contentieux assez nourri qui recouvre finalement toutes les problématiques de barrières à l'entrée qui ont été évoquées ce matin, à savoir les barrières financières, techniques et informationnelles. Alors, on a deux types de contentieux. Le contentieux devant l'autorité parce qu'on a des fonctions, on exerce des fonctions quasi juridictionnelles, à travers donc notre pouvoir de règlement de différend et notre pouvoir de sanction, enfin de déclencher des procédures en manquement, puis de sanctionner le cas échéant. Vous allez voir que ce contentieux, à travers les exemples que je vais vous donner, contribue à la levée de ces barrières à l'entrée. L'autorité, à travers ce type de contentieux, a un pouvoir qui est quasi réglementaire. Et puis on a aussi le contentieux des décisions de l'autorité. Donc c'est quand les décisions de l'autorité sont contestées, alors soit devant le Conseil d'État pour les avis tarifaires et autres décisions de l'autorité, soit devant la Cour d'appel de Paris, et là c'est uniquement pour les règlements de différend. La Cour d'appel de Paris a une compétence en matière concurrentielle et les règlements de différend sont assimilés à cette matière. C'est la même chambre. Donc, vous allez voir aussi à travers les exemples que je vais vous donner que le contentieux des décisions de l'autorité contribue, lui, à clarifier le droit. Parce que, comme vous le savez, aussi bien au niveau européen qu'au niveau français, on n'est pas forcément aidé par les textes. On a une assez grande marge d'appréciation en matière de régulation. Et donc, bien souvent, il y a des contentieux sur l'interprétation des textes. Voilà. Alors, l'autorité a connu deux grandes catégories de contentieux. Je vais vous donner des exemples sur les 2 ou 3 dernières années pour vous montrer à quel point ça peut être nourri. Donc, il y a le contentieux de l'accès aux infrastructures essentielles, donc l'infrastructure ferroviaire, bien sûr, mais aussi les installations de services telles que les gares. Donc, ça concerne aussi bien l'accès tarifaire que l'accès technique et opérationnel. Et on a le contentieux de l'accès aux données, donc pour l'ouverture à la concurrence des services publics. Et là, donc, on est dans des problématiques de barrières informationnelles. Alors voilà, donc je vais pas détailler évidemment tous les exemples de contentieux, je vais juste vous dire, pour illustrer donc les grandes questions sur lesquelles l'autorité ou les juridictions compétentes ont été appelées à se prononcer à travers ces contentieux. Et je vais donc vous donner une vue très très macro de ces contentieux, étant entendu que vous aurez les références, si vous le souhaitez, à travers le plan que j'ai remis aux organisatrices de ce séminaire, avec toutes les références des décisions dont je vais parler, si vous voulez vous y reporter. Alors, on va commencer par le contentieux de l'accès aux infrastructures essentielles, le contentieux tarifaire. Donc, je ne sais pas si vous le savez, en France, enfin, je pense qu'Olivier l'a évoqué ce matin, en matière tarifaire, donc l'autorité a un pouvoir d'avis conforme sur les tarifs d'accès à l'infrastructure ferroviaire et aux installations de services. Donc un pouvoir d'avis conforme, concrètement, ça veut dire que les tarifs deviennent exécutoires après avis conforme de l'autorité. Alors, premier exemple de contentieux, on a eu un recours de SNCF Réseau contre l'avis de l'autorité de 2019 qui portait sur le document de référence de Réseau pour l'année 2020. Et ensuite, le Conseil d'État donc, a rendu une décision le 27 novembre 2020. Et cette décision est intéressante à plusieurs titres. Alors, qu'est-ce qu'il avait de spécial, l'avis de 2019, et pourquoi il a été contesté par SNCF Réseau ? En fait, l'autorité avait émis un avis favorable sur l'ensemble des redevances, sauf une, la redevance de marché qui était applicable aux services conventionnés. Donc les services conventionnés, c'est les services publics qui ont donc passé des conventions avec les autorités organisatrices de transport et qui ont la particularité d'être subventionnés par les autorités organisatrices de transport. Et l'autorité, en fait, pour ces services, avait émis un avis favorable à hauteur de plus 1,8%, alors qu'SNCF Réseau voulait 2,4%. Alors le 1,8% correspondait au taux d'inflation qui pouvait être indexé à l'époque. Ça fait un peu rêver aujourd'hui, mais bon, à l'époque, c'était 1,8. Et donc, l'autorité avait refusé d'homologuer le tarif pour le surplus, ce que SNCF Réseau avait contesté. Alors, le Conseil d'État a annulé l'avis de l'autorité en ce sens qu'il n'était pas suffisamment bien motivé selon le Conseil d'État. Néanmoins, cet avis, c'est assez paradoxal, l'autorité a dû refaire son avis, revoir sa copie. Néanmoins, il y a eu 2 avancées jurisprudentielles importantes, même 3, à travers cet avis. D'une part, le Conseil d'État a reconnu à l'autorité la capacité à émettre un avis à hauteur 2, ce qui signifie concrètement fixer le tarif, en définitive, même si elle ne le fixe pas en première intention. En tout cas, elle peut mettre le plafond, acceptable selon elle. Par ailleurs, le Conseil d'État a reconnu que l'autorité n'était pas liée par la trajectoire financière du contrat de performance qui lie SNCF Réseau à l'État, ce qui est quand même quelque chose d'important. Sinon, effectivement, ça réduirait son pouvoir de régulation. Et le Conseil d'État, et c'est en ça que cette décision est très importante, et vous allez voir pour les prochains avis tarifaires, ce sera vraiment important, le Conseil d'État a précisé les critères d'analyse de la soutenabilité de la redevance marché en disant que la majoration tarifaire ne devait pas conduire les autorités organisatrices de transport à prendre des mesures susceptibles d'affecter le service public, d'affecter l'utilisation de l'infrastructure ferroviaire. C'est-à-dire que pour des services qui sont subventionnés par les autorités organisatrices de transport, on peut difficilement voir quelle est la sensibilité au prix du marché aval. Il est vain d'aller rechercher la sensibilité au prix des autorités organisatrices de transport, parce qu'il s'agirait de faire un examen budgétaire qui est vain. Alors, on va voir si ces majorations tarifaires sont de nature à modifier l'équilibre du contrat et surtout à conduire les AOT à diminuer leur circulation, le nombre de circulations et donc la consistance du service public. Voilà, donc ça, c'était les avancées qu'on a obtenues à travers cet avis. Alors, pour la petite histoire, l'autorité a revu sa copie. Elle a fait exactement la même chose, un avis à hauteur de plus 1,8%, mais elle l'a motivé différemment. Elle l'a motivé en suivant les instructions du Conseil d'État sur la lecture qu'il convenait d'avoir du critère de soutenabilité. Voilà, donc ça, c'était pour le premier exemple. Un deuxième exemple que je vais juste évoquer très très rapidement qui concernait le document de référence des gares, donc le tarif d'accès aux gares. Le 11 février 2021, l'autorité a rendu une décision d'incompétence à l'encontre de la région Nouvelle-Aquitaine qui avait saisi l'autorité d'une demande de règlement différent portant sur le tarif du document de référence des gares pour l'année 2020. Et pourquoi on s'est déclaré incompétent ? On a considéré que, ayant un pouvoir d'approbation exempté du tarif, on ne pouvait pas, à travers un règlement différent, le remettre en cause ex post. Ça paraît complètement aberrant. Et bon, heureusement, la Cour d'appel nous a donné raison, sinon on portait atteinte à la portée de ce pouvoir d'avis conforme, qui est pour nous le levier majeur de régulation du secteur de l'accès à l'infrastructure ferroviaire. Donc, à travers cette décision, donc la décision de la Cour d'appel du 27 octobre 2022, on a eu confirmation de ce qu'on ne pouvait pas intervenir à la fois exempté et ex post sur un seul et même tarif. L'intervention exemptée étant de nature à garantir que le tarif est conforme aux principes tarifaires et qu'il n'y a pas de discrimination d'accès, etc. Voilà, donc ça c'était pour le contentieux tarifaire. Alors maintenant, je vais vous parler du contentieux de l'accès technique et opérationnel aussi à travers 2 exemples, donc de l'accès technique à l'infrastructure ferroviaire. Alors, un exemple assez récent, enfin 2 exemples assez récents, un règlement différent. Donc l'autorité a adopté une décision le 28 juillet 2022 qui porte règlement des différends opposant 4 entreprises ferroviaires de fret contre SNCF Réseau, donc, et qui concerne des procédures en lien avec l'allocation des sillons, l'encadrement et l'utilisation des capacités réservées à réseau pour les travaux, et puis sur les principes et les procédures d'indemnisation en cas d'annulation d'un sillon ou de modification substantielle d'un sillon. Alors donc c'est un différend qui concerne bien ces conditions techniques et opérationnelles d'accès. Alors je ne vais pas vous faire un détail de toutes les demandes, il y avait une trentaine de demandes, c'était un contentieux qui était protéiforme et qu'on a mis 18 mois à instruire. C'était vraiment, c'était un contentieux assez complexe. Mais ce qu'il faut retenir, c'est que les principaux griefs des entreprises de fret, c'était un manque de transparence quant aux critères d'allocation des sillons et quant à la réservation par SNCF des plages travaux qui lui étaient réservées, et puis surtout à la restitution de ces plages travaux en cas de non-utilisation effective. Donc un manque de transparence, un manque d'efficacité et d'incitation à la performance dans la mise en œuvre du processus capacitaire. Et puis par ailleurs, le dernier grief, c'était des principes et des procédures d'indemnisation qui étaient inéquitables. Alors, à travers ce règlement de différend, l'autorité a fait droit à 2/3 des demandes des EF et prononcé des injonctions et des recommandations, dont ensuite elle va s'assurer du suivi à travers plusieurs vecteurs, et en particulier l'avis qu'elle émet chaque année sur le document de référence de réseau. Donc c'est un avis simple, mais qui permet à l'autorité d'assurer le suivi de ses recommandations, de ses injonctions. Et évidemment, si des injonctions ne sont pas suivies d'effet, derrière, on peut déclencher une procédure de sanction. Donc voilà, ça c'était pour cet exemple. Donc on voit bien, à travers cet exemple, que l'autorité, à travers les injonctions qu'elle a prononcées, a précisé des obligations d'accès équitable qui existent, bien sûr, mais qui sont interprétées par l'autorité et qu'elle a exercé à travers cette décision un pouvoir quasi réglementaire, puisque le non-respect de ces injonctions pourra donner lieu par la suite à des sanctions. Je vais vous parler aussi d'une procédure en manquement, qui est récente aussi et qui est assez topique parce que pour la première fois, l'autorité a saisi la commission des sanctions. Alors, il s'agit de la décision de l'autorité du 20 octobre 2022 qui porte donc sur une procédure en manquement qui avait été ouverte à l'encontre de SNCF Réseau pour méconnaissance de plusieurs décisions de règlement de différends qui avaient été rendues en 2013. Et donc, en 2019, on a 5 entreprises de fret qui ont demandé à l'autorité d'ouvrir une procédure en manquement à l'encontre du gestionnaire d'infrastructure en raison donc de la méconnaissance de ces injonctions qui portaient notamment sur l'information transmise aux entreprises ferroviaires à travers les systèmes d'information de réseau tout au long du processus capacitaire. Et donc, l'autorité a constaté les manquements et a mis en demeure SNCF Réseau en mai 2020. À travers cette mise en demeure, elle a prononcé 4 injonctions. Il y en a 3 qui ont été satisfaites. Alors on voit aussi l'efficacité que peut avoir une procédure de sanction. C'est qu'en définitive, en général, on n'est pas obligé d'aller jusqu'à la sanction. Mais là, pour une des injonctions, elle n'avait pas été satisfaite. On a donc saisi la commission des sanctions qui, aujourd'hui, est en train d'instruire le dossier. Un dernier type de contentieux, très rapide. Dernier type de contentieux, c'est le contentieux de l'accès aux données. Alors ça, c'est assez important. C'est en fait l'enjeu, c'est la communication par les entreprises ferroviaires. Alors cette fois-ci, on n'est plus chez le gestionnaire d'infrastructure, on est du côté des entreprises ferroviaires, donc des entreprises de transport de voyageurs. Et l'enjeu, c'est la communication par ces entreprises titulaires de contrats de service public des données nécessaires à la préparation par les autorités organisatrices de transport des appels d'offres pour l'ouverture à la concurrence des services publics. Donc ça, c'est un vrai sujet aussi. Et donc, c'est un contentieux qui porte essentiellement sur le périmètre des données qui sont à communiquer à ces autorités organisatrices des transports, donc tant le périmètre temporel que spatial. Et donc, c'est un contentieux qui a été assez protéiforme. Alors, ce qui était intéressant dans ce contentieux, c'est qu'il y a eu une décision de règlement de différend qui a été contestée en appel. Un recours donc au fond devant la Cour d'appel de Paris qui a conforté une nouvelle fois l'interprétation des textes existants par l'autorité, donc sur le périmètre des données à transmettre qui était contesté par SNCF Voyageurs. Mais c'est aussi un contentieux qui a donné lieu à l'ouverture d'une procédure en manquement, parce que tant que la procédure devant la Cour d'appel était pendante, SNCF Voyageurs freinait vraiment l'exécution de la décision de règlement de différend, puisqu'elle la contestait. Donc, ça a donné lieu à l'ouverture d'une procédure en manquement, puis, in fine, à la clôture de cette procédure, la Cour d'appel ayant fini par trancher en faveur de l'interprétation qui avait été donnée par l'autorité, et SNCF Voyageurs ayant eu la sagesse de se conformer aux injonctions de l'autorité. Donc voilà, c'était le dernier contentieux.
Excusez-moi. Merci pour ce très intéressant exposé et avec un contentieux assez nourri. Et puis, la situation française avec sa séparation des autorités administratives et judiciaires et un Conseil d'État et une Cour d'appel qui devient une juridiction administrative judiciaire. Mais voilà. Alors, now it's time for questions from the floor. I don't even have to ask something. The question is there. Ex officio.
The other one, on the other side.
Yeah, no, it's fine. It's just because too many people are. Yeah, it was a topic that was only, you touched upon that, Juan. It's the ticketing, the problem with ticketing. Because, for example, I know that ART is not competent on that matter, it's Autorité de la Concurrence, so maybe that's not like in the scope of most of the regulator. Because I think that's a big debate. I spoke a little bit with Andrea that told me that some new entrants, they don't want to be on the incumbent platform. That's the case of NTV. But that's not the case of all new operators. For example, Locomore in Germany, they want to be sold by Dutch Bahn. And also Sagareil in Sweden and MTR in Sweden. So I think there is not so many cases. You told about Germany, so I'm very interested to have like the German story about the fact that Locomore was not sold by DB. So that's only open access. I'm only speaking about open access because I think there is no problem with public service obligation. So is there any case regarding the fact that Deutsche Bahn is not selling competitor on its platform and Locomore told that's why they go bankrupt, and in other countries, in Italy apparently NTV you don't want, but Arenaways, I don't know if they want it before. Arenaways was the first competitor in Italy, went bankrupt also, so I don't know if they asked for that. And sometimes I know that regulator, you don't deal with that, so maybe that's competition authority, so maybe the Spanish has something to say, or like the professor, I don't know. In UK it's different because you have this ad hoc, like the train operating company, so you don't have any problem.
We actually had a case before the AGCM, that is a competition authority, and it regarded ticketing and timetables, because when you sell together high-speed and regional trains, you could do that only through Trenitalia. And Italo was complaining, there was an abuse of dominant position that was actually found. That's why the competition authority was competent, because it was against 102 of the treaty rather than regulatory question. So the case was closed with commitments, actually.
Do you have the number of the case, just, or if not, no problem. I will look for it.
If you write me an email, I can tell you. Write me an email.
Sorry. Yeah, I think we have to distinguish two scenarios, I think. When the UK introduced competition and in other countries started, this ticketing issue was perceived as a purely market entry barrier, and you have to manage fragmentation, but it has evolved, and right now it's not just a bilateral issue between the newcomer and the incumbent, but it's the fact that digitalization has completely transformed distribution systems. And now we have new players, and we have the platforms, and I think I don't want to do it, but I think we have one of these platforms here in the room. So this is a game changer. So it's not anymore a horizontal debate between incumbent and newcomers. It's a vertical debate between digital platforms and the service providers, and much richer and with a lot of implications. So the cases, as far as I know, have been mostly competition law cases, because there is very little, other than the UK, very little legal basis for national regulators to step in so far, because the Commission is working on a piece of legislation about it. So
No, exactly. I wanted to just mention that there will be regulatory action from the Commission on this. So it's in motion. We have not concluded yet, but it was very clear and recalled at the highest level that we want to have simple solution, non-discriminatory, so that we can boost the market. So it's not only about competition rules, and we have antitrust issues, there will be regulation.
Yeah. If I can add also some element, Patricia told very well about Italo position. They built their system, they invest a lot in revenue management and so on, so they decide to use but for example, they had problem, especially for the regional train, but this problem is solved in the last period. For example, using one of these platforms, without telling the name, but they are selling some regional train of Trenitalia together with the high-speed train on the website of Italo, together with also buses, long-distance buses that is named Itabus, that is another company. So right now they are making integration. What is the real point for the consumer? That finally you don't have insurance that if you miss some train, if you miss some whatever product, you have not these kind of things. But I think that also for that there's a market. I spoke with the many companies that start to sell like small insurance to cover you the risk that you lose a train, or you're losing the bus, or you're losing the regional train. Because, you know, it's just statistic. If it's a very small amount, probably you have to pay €1 to have this connection for. So there are new product that is already there. There's already some company starting to make this kind of offer to make this integration that already exists with a platform to give a good solution for the consumer. Of course, it's changed a lot in the last 10 years, 20 years, and they know the different position from Westbahn also at the time, and there was also MTRX and so on, MTR at the time, Express, that have this kind of different position. But I think that is that the market is evolving about this.
Another question? Please.
Yes, if I may, it's a reflection rather than a question. As much as we notice very different systems at work during the morning, there is also very diverse structure of the litigation system. And if you combine the two, it makes it really difficult to perceive harmonization of EU principles on the ground. Depending on the nature that a member state wants to provide for a regulator, depending on the structure of the judicial system at the domestic level, and depending on the scope of judicial review. I was listening with really great interest, and I think I could relate with many cases to many of the ones that have been mentioned today concerning the scope of judicial review of independent regulators. The moment in which the judge goes close to replicating the work that has been done by the independent regulator, there is little scope for independent regulation left. In terms of technical assessment, at least as far as Italy is concerned, we have a very clear separation of what is the scope of action for judicial review concerning the application of sanctions, and there we can understand that the judges go deep and in the merits of the decision as far as the sanctioning system is concerned. But as far as the technical side of regulation is concerned, it is a very delicate and fine line for the judge to reassess what is the method applied by the regulator and how it has applied it. So by listening to all the interventions that have been made in the afternoon so far, I was under the impression that not only we are not alone, of course, but also that, you know, if we couple the autonomy in the definition of the role of regulators with that, which of course concerns the judicial system, you know, there is little scope for harmonization. Thank you.
What you say raises the question of the scrutiny of the judicial on the power of the regulatory authority, the degree of scrutiny. And in France, we may say that the State Council, which is in the heart, you could say, has a rather liberal view of the extent of the competence of the regulator. But its scrutiny is rather precise. Of course, there are fields of discretion of the regulator, but it's the nature of our State Council makes that, you know, it's used to control administration, and whether it's ultra vires or full jurisdiction, especially for the fines, no. But there is the problem of technical. I wanted to ask a question about what is the share in the different litigation between the general law of competition and the special law of regulation. It's interesting because we have in many, well, in the United States there is a, what's do you use in your legal systems the notions of general competition law because they are included in the regulatory frame, or is there a kind of wall between I've got regulatory special norms and bye-bye the competition law? That's my question.
My view is competition law is the answer to an imbalance, and try to do away with this imbalance, including maybe damages. Yeah, regulation law is to try to order the market. Yeah, in the general sense, to prevent imbalances. And also in advance, and if the regulator has discovered imbalances, to do away with them. So actually, regulation law is a special form of competition law. However, there seems to be a race. And the race was triggered by the regulators refraining from deciding. Whenever the regulators did not decide, the parties affected tried to circumvent this by calling for the competition courts. And that's why we have this twofold development between regulation and antitrust law, now from the German point of view. Yeah? So actually we had, it was a kind of circumvention. The parties did not seek justice, or they could not find justice with the regulators, and so they went to the civil courts. Yeah, the civil courts deciding on civil law grounds or on antitrust law grounds. But substantively speaking, I think regulation law is a special form of competition law. And there are, we could imagine cases where there is no space anymore for the elevation of competition law. Yeah? But also this is disputed. The Commission, the European Commission would say, no, whenever we want to do, we could scrutinize on behalf of competition law whatever the regulatory bodies have said. Yeah, very tricky.
Okay. Now this is this is just to point out that this is a very topical issue. That is the scrutiny of decisions of regulatory bodies and the line that should be drawn between what the regulatory bodies are empowered to do and what the courts, the civil courts, are empowered to do. So I'll just give you the reference to, recent case law of the court. One is CTL Logistics. It's no longer so recent, but it's still quite similar. It concerns the German situation where the ECJ, so the Court of Justice, said that civil courts could not substitute themselves for the judgment of the regulatory body. And they could intervene after the regulatory body had examined the matter in substance. There's another follow-on case, which is the DB Station. Yeah, DB Station. A slight nuance over this, but just to say that there is a growing body of jurisprudence on the questions of competencies, and also there's one preliminary ruling which has not yet been decided by the court, if I'm not mistaken, and it concerns a Czech case. There it's really about whether a court which is exercises powers of judicial review over a decision of a regulatory body can replace the assessment with its own. I'll give you the reference, I was looking for it. It is case C-222 of 21, and it's from a Prague, Czech, Prague court. So this was lodged in March 2021, so we'll have to wait what comes out of it. So watch this space.
And maybe from the competition point of view, I mean, in the treaty, you have the transport chapter, but you have also the competition chapter. So you may have certain infringements or certain problems that can then be addressed from both aspects. I would like also to point out that we did not discuss it today, but in terms of litigation at national level, also national competent authorities are competent. So here we have regulators, but we don't have, except for Spain, sorry, we don't have the competent authorities. I mean, they are instrumental to provide redress mechanisms, and also, which is not very known, but for state aid, the national judge is, in principle, the first port of entry at national level, to actually conclude on the existence of state aid. And so this is also not very well known, but we don't have the impression there is much litigation at national level on state aid matters. But in the future, this may be creating a lot of litigation to support, the opening of the rail market for passengers.
Mm-hmm. Oui. Well, I am of the same opinion as Mr. Otte. I would also say that railway regulation is some sector-specific competition law. And furthermore, I wondered a little bit about the decision I quote by the ECJ on the relationship between railway regulation and competition law, because in that decision the ECJ has acknowledged some sort of supremacy of railway regulation, which in my view, on the other hand, is totally contrary to the fact that competition law on a European level is primary law, whilst railway regulation is only secondary law. But however, competition law even fulfills some sort of catch-all function where a particular case does not fall within the scope of railway regulation. I give you an example from Austria 10 years ago. Namely, there was a nationwide timetable edited by ÖBB, Austrian Federal Railways Infrastructure. And as you can imagine, the westbound trains were not included in that timetable. And that case, or that fact, was challenged before the competition authorities, since the issuing of timetables at that time did not fall under services covered by access, and and the case was solved on the basis of competition law, and yes.
Oui, moi j'aime bien cette question de l'articulation du droit de la concurrence.
Moi aussi.
Ouais, j'aime bien cette question. On se la pose souvent, à vrai dire. Et en fait, je ne pense pas qu'il y ait une concurrence entre ces deux types d'autorité et de droit. Je crois vraiment que le droit de la régulation économique, c'est une application sectorielle du droit de la concurrence, que les deux branches du droit, et c'est valable aussi dans le domaine de l'énergie, des télécoms, on poursuit les mêmes objectifs de bon fonctionnement concurrentiel du marché, mais à travers des outils différents. Le régulateur économique intervient exempté, construit quelque chose et dans la prévention, davantage dans la prévention, tandis que les autorités de concurrence sont davantage dans la répression. Alors l'objectif, évidemment, c'est toujours la même chose, c'est le bon fonctionnement du marché, mais je crois vraiment que c'est complémentaire comme compétence. Par exemple, nous, on ne peut pas sanctionner des pratiques passées. Par exemple, vous avez vu à travers les exemples de contentieux que je vous ai donnés, typiquement sur le contentieux donné, qui a duré quand même un certain temps. Je vous ai dit que SNCF Voyageurs avait eu la sagesse de finalement rentrer dans l'ordre. Néanmoins, moi, je ne peux pas, dès lors que les injonctions qui ont été émises par l'autorité ont été satisfaites, voilà, je ne peux pas sanctionner, j'ai plus aucune raison de sanctionner, je clôt la procédure. Alors qu'une autorité de la concurrence aurait pu sanctionner une pratique anticoncurrentielle pendant un certain temps. Parce que, de facto, ça a pu retarder la concurrence ou l'ouverture à la concurrence dans la région concernée pendant un certain temps. Donc, on voit bien qu'on n'a pas les mêmes outils. Et par ailleurs, alors moi, je crois qu'en fait, que l'autorité de la concurrence peut prendre le relais de l'autorité sectorielle qui serait compétente en premier ressort. Elle peut prendre le relais soit pour sanctionner des comportements passés que l'autorité de régulation sectorielle ne peut pas sanctionner, soit pour sanctionner plus large quand, par exemple, l'autorité de régulation sectorielle n'a pas de compétences à l'égard de certains acteurs. Je pense typiquement, par exemple, nous, on régule les gestionnaires d'infrastructures, entreprises ferroviaires, etc., pas les constructeurs. Quand il y a des problématiques de barrières à l'entrée qui sont liées à des constructeurs, Hitachi, Alstom et compagnie, on n'a absolument aucun pouvoir sur eux. Donc là, éventuellement, on serait intéressé que l'autorité de la concurrence puisse prendre le relais, le cas échéant, s'il y a une barrière à l'entrée identifiée du fait de pratiques de constructeurs. Voilà, donc c'est des exemples pour expliquer la complémentarité entre ces deux types d'autorités, et non pas, il n'y en a pas une qui est là pour pallier quand il y a une carence de l'autre. Je ne crois pas,
You've got the...
Thank you. Well, I think this question on the boundaries between competition and regulation is not new, and I think it is one of the reasons for the creation of the CNMC, putting together in a only body regulation and competition. Indeed, there were different decisions for very similar situations in the telecom market, ending in decisions from the regulatory body and ending up also with fine from the competition authority. And the reaction from the legislative power in Spain was to create a single body trying to unify and put consistency in the type of decisions. And in reality now, as you have mentioned, we did this. We try to avoid forum shopping, discussing internally when a complaint comes on transport, but also in telecom or energy. deciding and analyzing which is the best tool to address the complaint. But now we do this internally, trying to find the best tool.
I give you the floor, just saying that I wouldn't say that the law of regulation is a special part of the law of competition, in as much the law of regulation much deal with other public interests that the public interest, indeed, of the protection of the competition or public order. So I would be, perhaps it's a French way of saying things, but I would be more cautious about, even if, of course, the competition is quite important. So that's what there is. And then I think that we have to go to the coffee. No? C'est pas ça? Tu es dans les temps, non? Ah non, c'est jusqu'à 16h, c'est jusqu'à 4h. Ah ben, non, encore, alors ça va. Ah non, c'est dans 5 minutes. So,
maybe just one final sentence about your remark. You said the legal consequences are different. Competition law, damages, fines, private enforcement on one hand, and regulation about the market conditions. But now my question is, the prerequisite of these decisions are inadequacy and imbalance. And could it be that the regulator says the charge is adequate and balanced, and the competition court or office says, well, there is an imbalance and it's inadequate? The thing is, dealing with the basis could be contradictory, and that's a reason why the relationship between these two laws and then also between these two jurisdictions are unsettled in a way. It shall not happen that the offices, the bodies, and the courts define inadequacy differently. That would be detrimental.
And then,
thank you very much. I would have another comment on this discussion. It's also about legal certainty. The problem in Germany in all these cases was that files or complaints or files were launched at the civil courts much later, when all the delays were already over, to file a complaint at the regulatory authority or also at the competent administrative courts. So we are dealing now and still discussing track access charging systems of the past, of the years 2006 and onwards, and I'm afraid we will be discussing these cases and also the regulatory authority for a couple years on. So it's also about legal certainty, and I fully share the opinion that it's a lex specialis regime, which is a regulatory law, and it prevails. But this is another aspect of the discussion from my point of view. Thank you.
Maybe, of course, I would like maybe to raise a bit the issue that sometimes also some issues are not tackled by the regulators. I mean, from our perspective, especially on the public funding. I mean, I work in the state aid area, and Article 6 and to 8 of the recast directive actually requires that, for example, there is no cross-subsidization. And if, I mean, you said that it should be effective, but we don't see how those provisions are actually being applied by the regulators or the body held responsible when transposing the directive. So you're saying that it's complementary, but I have the impression that for some of the provision of the recast directive, there is no action, for example, on those matters.
our subject, of course, is indeed in a European legal framework. So now it's time for Europe. And we'll have a presentation by a duo for the European litigation with our colleague Stéphane Rodrigues, senior lecturer at Panthéon Sorbonne, and Alfredos Theodorakopoulos, who is legal assistant at the Court of Justice of... you have the floor.
Thank you, Chairman. Let me first thank my colleague and friend, Aurore, for his kind invitation and organization. Congrats. Thank you also to Professor Boiteau for his welcoming address. And last but not least, thank you to my co-pilot, my duetist, Andreas. It's the first time, I think that will be not the last one, I hope. Let me switch to French to pay tribute to the translators. Donc, nous partons à Luxembourg. Vous vous rappelez de ce que nous a dit Aurore ce matin, et l'affiche de la gare de Bruxelles vers le Luxembourg. Beaucoup d'avocats connaissent cette gare puisqu'elle se rend justement vers Luxembourg et le siège de la Cour de justice. Et je me suis dit, en accord avec Andreas, pour réfléchir un peu au rôle, à l'impact du juge dans cette régulation et cette ouverture à la concurrence des passagers du transport par rail, qu'est-ce que disait la Commission, partant de la doctrine de la Commission. Alors, ce n'est pas véritablement une doctrine qu'on a trouvée, mais c'est un rapport qui avait été commandé par la Commission en 2012. Vous verrez, on vous a mis quelques références. Désolé, on ne l'a pas fait en PowerPoint. Hein, on était un peu sous le rush. Mais vous aurez au moins les références du rapport en question, qui avait été commandé par la Commission pour les 10 ans de la mise en œuvre de la première directive de 91. Et c'était intéressant parce que ce rapport insistait notamment sur les problèmes de barrières pour former le marché du transport ferroviaire et s'intéressait aux acteurs du changement. Et il y avait dans ce rapport, qui fait 300 quelques pages, 3 ou 4, pas plus, références à des arrêts ou à des conclusions d'avocat général de la Cour de justice. Et bref, le rôle était très limité, pour reprendre l'expression du collègue Tony Prosser tout à l'heure. Alors on s'est dit, mais 10 ans après, 2022-2023, est-ce que ce rôle a évolué? Est-ce que si on refaisait cette étude 10 ans après, au regard cette fois-ci de l'entrée en vigueur de la directive de 2012, est-ce que le rôle du juge serait toujours aussi limité? Alors une chose est sûre, c'est qu'il n'y a pas eu explosion du contentieux. Le contentieux reste encore assez rare et du point de vue de l'aspect concurrence, la mobilisation des règles de concurrence du traité n'est pas légion dans la jurisprudence. Mais ça, c'est une question de perception. Si on élargit le concept de concurrence comme étant un élément ou une mise en œuvre de l'objectif plus général de marché intérieur, et il y aura peut-être une discussion avec le représentant de la DG Concurrence, mais je m'appuie sur le protocole 27 annexé au traité, qui met bien en avant que la compétition n'est qu'un élément pour forger ce marché intérieur. Alors là, sous cette perspective-là, on peut élargir le champ de la jurisprudence, et heureusement, pour les organisateurs du colloque, ça a permis quand même de nourrir un peu notre contribution. Alors, on mettra en avant donc 2 catégories de contentieux. Le contentieux lié à l'achèvement du marché intérieur, ce fameux espace ferroviaire unique voulu par la directive de 2012 et celle de 2016 depuis lors. Et puis, le contentieux lié, proprement parlé, à l'application des règles du traité de concurrence, sur la concurrence. S'agissant tout d'abord, et vous l'aurez compris, je m'occuperai de la première partie sur le marché intérieur et Andreas prendra le relais sur les règles de concurrence. Sur l'aspect contribution à la réalisation du marché intérieur, il est toujours intéressant de revenir aux fondamentaux, au texte de base, et notamment au considérant numéro 2 de la directive de 2012, qui met bien en avant le lien, justement, entre intégration, donc également concurrence au sens implicite du terme, et la réalisation du marché intérieur. Et comme vous le savez, mais c'est juste un rappel, il y a deux manières, dans l'esprit des rédacteurs du traité, de parfaire, de parachever le marché intérieur. Il y a l'approche qu'on appelle communément l'intégration négative, c'est-à-dire qu'on fait application des règles des traités qui sont des obligations de ne pas faire, ne pas abuser de sa position dominante, ne pas abuser, ne pas s'entendre d'un point de vue anticoncurrentiel avec les petits copains, donc une approche d'intégration négative, mais qui est complémentaire de l'approche de l'intégration positive, où on va poser des règles en amont pour harmoniser les législations nationales et faire en sorte qu'il n'y ait pas de barrières, notamment réglementaires, à l'entrée du marché. Eh bien, ces deux outils, on va le voir pour le deuxième, évidemment, et pour l'aspect concurrence, c'est particulièrement développé. Pour l'aspect marché intérieur, il n'y a pas, à ma connaissance, de jurisprudence, en tout cas significative, faisant application directement des principes de libre circulation dans le domaine du transport de passagers ferroviaire. En revanche, et ça a été dit par plusieurs des intervenants tout à l'heure, il reste la question de l'interprétation des textes, et notamment de l'interprétation de la fameuse directive de 2012. Et à cet égard, je voudrais insister sur deux aspects. D'une part, le rôle clé qui est joué encore aujourd'hui par le principe de libre circulation pour permettre une ouverture à la concurrence. Et deuxièmement, on verra l'importance, évidemment, des conditions d'une régulation sectorielle adéquate. Alors, s'agissant du principe de libre circulation ou de prestation de services, d'ouverture des services, et par là même du marché des services, il est toujours intéressant aussi de constater que la Cour n'hésite pas à mettre en avant plusieurs considérants de la directive, notamment les considérants 3, 7, 8, 26, pour faire le lien entre efficacité du système ferroviaire, intégration dans un marché concurrentiel et stimulation de ce qu'on appelle une concurrence loyale. Ce sont dans les considérants qui sont en général utilisés par la Cour pour l'interprétation de la directive. Et on en a trois illustrations. Je serai très bref puisque le temps est compté. Mais tout d'abord, la question s'est posée du champ d'application du marché d'infrastructures ferroviaires, avec la question notamment de la qualification des quais de voyageurs. Alors j'irai très vite sur cette première affaire, puisqu'elle a déjà été mentionnée par notre collègue austro-allemand ou germano-autrichien, je ne sais pas. Autrichien, voilà. C'était une affaire autrichienne d'ailleurs. Mais ce qui est intéressant, c'est que la question s'est posée pour la Cour, si c'était un peu technique, mais est-ce que les quais de voyageurs relevaient de l'infrastructure, pour faire court, ou plutôt des services? Et la Cour a insisté pour retenir la qualification liée à l'utilisation de l'infrastructure, pour insister sur le fait que qui dit concurrence dans ce marché dit le meilleur accès possible aux infrastructures, dont les quais de voyageurs. Pour l'accès aux services, en revanche, mon impression, c'est que la Cour n'a pas voulu aller aussi loin que pour les infrastructures. On est toujours au-dessus, c'est le petit 2, Condition of Access to Services. Une autre affaire, jugée en 2021, qui se posait la question de savoir si le fameux principe de non-discrimination, qui a été plusieurs fois rappelé ce matin ou tout à l'heure, l'accès non discriminatoire aux installations de services, est-ce que ça s'imposait uniquement aux exploitants de ces services ou également aux propriétaires de ces installations notamment? La Cour tranche pour dire les propriétaires ne sont pas concernés par les objectifs de concurrence. Seuls les exploitants des installations de services doivent permettre un accès non discriminant. Intéressant, puisque ça renvoie peut-être un peu au débat qui était à la fois politique et juridique de savoir si on imposait notamment la séparation des opérateurs et des propriétaires des infrastructures. Enfin, troisième illustration, sur l'aspect tarifaire, qui a été plusieurs fois évoqué, notamment par la directrice juridique de l'ART. L'aspect tarifaire a permis notamment d'illustrer dans la jurisprudence de la Cour la question des redevances d'infrastructures et de services, et notamment la notion qui me paraissait intéressante quand on parle de concurrence dans le marché, de compétitivité optimale des segments du marché. C'est un concept que l'on trouve à l'article 32 de la directive de 2012, qui permet notamment une majoration tarifaire de la part des États membres, si elle est justifiée et si le marché s'y prête, selon la formule consacrée. Et c'est intéressant parce que la question s'est posée de savoir si cet objectif d'une compétitivité optimale pouvait s'appliquer également à des segments de marché hors concurrence. Par exemple, un segment de marché où il y a un contrat de service public qui opère. Eh bien, la Cour de justice va dire, mais il ne faut pas confondre compétitivité et concurrence. Effectivement, la concurrence n'a peut-être pas son mot à dire lorsqu'on est sur une ligne sous OSP, mais en revanche, la compétitivité, l'objectif de compétitivité demeure, y compris sur des lignes sous contrat de service public. C'est l'affaire LATRAILNET qui est citée ici. Reste, et j'en viens au deuxième volet, reste que l'interprétation au cas par cas de certaines notions de la directive 2012 ne suffit pas à permettre une totale ouverture à la concurrence. Encore faut-il aussi qu'il y ait les conditions nécessaires à une régulation sectorielle efficace. Et là, je voudrais insister sur deux aspects qui ont déjà été évoqués ce matin ou tout à l'heure en début d'après-midi. La régulation des contrats de service public et la question de l'indépendance du régulateur. En s'appuyant sur des jurisprudences relativement récentes, sans aller retourner aussi loin que l'application de la directive de 91 notamment. Sur les contrats de service public, je voudrais attirer votre attention sur un arrêt relativement récent de septembre 2022, certes qui n'était pas dans le secteur du transport ferroviaire, qui était celui du transport de bus, mais qui conduit à une interprétation du fameux règlement de 2007 sur les contrats de service public, applicable également au secteur ferroviaire. Donc, en d'autres termes, les leçons qu'on peut tirer de cet arrêt pour le transport de bus sont, à mes yeux, applicables par analogie au transport ferroviaire de passagers. Et la question se posait de savoir, il y avait plusieurs questions préjudicielles, il y en avait 5 ou 6, mais j'en retiendrai 2. La question de savoir si le fait, c'était le gouvernement estonien qui imposait aux transporteurs des tarifs, de la gratuité des tarifs pour certaines catégories de passagers, notamment des passagers handicapés. Est-ce que ça devait résulter uniquement d'un contrat de service public ou ça pouvait être aussi imposé par voie de règle générale, comme le prévoit la directive? Et la Cour confirme que par règle générale, on peut se référer à un texte de loi, comme c'était le cas pour la loi estonienne en question, et qu'elle conduit alors à pouvoir imposer des obligations de service public en dehors d'un cadre contractuel, en dehors d'un mode conventionnel. Et alors la question qui vient juste après, puisque l'État peut l'imposer, pouvait-il, l'État estonien, imposer de telles obligations sans compensation, puisque c'était le deuxième apport de la loi estonienne contestée. Et réponse de la Cour, ah non, si vous imposez des obligations de service public, même en dehors d'un cadre contractuel, vous devez compenser. Alors je ne rentre pas dans le détail, la Cour va un peu plus loin et explique en quoi ça doit être compensé, et le représentant de la DG Concurrence ici maîtrise ça 10 fois mieux que moi. La Cour dit, mais il faut éviter toute surcompensation, et donc il faut faire une balance entre les recettes et les dépenses induites, avec éventuellement un bénéfice raisonnable. Ça vous parle tous, quand on parle ici, évidemment, du test Altmark, l'arrêt étant d'ailleurs cité 2 ou 3 fois par la Cour de justice dans cette affaire. Enfin, parce que le temps est compté, il n'y a pas de régulation sectorielle effective sans régulateur indépendant, mais là, je n'ai pas besoin d'insister, puisque ça a été rappelé au moins 10 fois depuis ce matin. Je vous renverrai à une affaire intéressante, pas tellement parce que ça touche aux autorités de régulation sectorielle en tant que telles, mais à d'autres organismes qui peuvent intervenir dans la régulation notamment technique, les organismes de sécurité, les organismes d'enquête, par exemple, qui étaient visés dans cette affaire. Ce qui est intéressant, c'est le degré de contrôle, l'intensité du contrôle de la Cour. Ça va faire plaisir à mon collègue Louvaris. L'intensité du contrôle, la Cour n'hésite pas à aller très loin dans la vérification de l'indépendance, à travers le budget, à travers la mise à disposition de personnel, à travers les liens de tutelle avec le ministère ou les opérateurs, ou les liens, avec les opérateurs, pour conclure en l'espèce que cette indépendance n'était pas garantie par la loi polonaise. Mais il est très clair que pour la Cour de justice, il n'y a pas d'ouverture effective à la concurrence sans régulateur indépendant. Et il n'en a pas non plus sans une application adéquate des règles de concurrence proprement dit. Je laisse la parole à Andreas.
Merci Stéphane. I'll continue in English. I would first of all like to thank the organizers of the conference and the Université Paris-Dauphine for the kind invitation. As Stéphane mentioned, I'll be focusing on the competition angle of the litigation before the EU courts. As has been said, I mean, litigation at EU level when it comes to competition law in the railway market is limited. And it's limited, first of all, when we compare it to the litigation we've seen in other liberalized markets, in other network industries, but also when we compare it to the litigation we have at national level or before national or EU regulatory authorities, DG Comp, of course, included. So what we can say, the two big themes, which will also be the two parts of my presentation, are that competition law at EU level in this sector has focused first on the interplay between the sectoral railway regulation and competition law. That's not a surprise. We've seen it also in other markets that have similar characteristics. And I will focus on the recent judgment of the court, which was also mentioned by other esteemed panelists, the DB Station case. And then I'll move on to certain specific examples of essential implementation of competition law in this area that found their way to the court. One case is very famous Article 102, abuse of dominant position in Lithuania. Again, the judgment was rendered a few days ago, and then I'll also mention very briefly two state aid cases, which I understand also my colleagues from the European Commission might also present, so I'll be brief on this one. Obviously, both Article 102 and state aid implementation of competition law are important in the sector, given the impact that certain anti-competitive practices when it comes to Article 102 or certain state intervention may essentially slower or even block the opening up of the market. So I'll directly move on to the first case, DB Station Service AG. It's I think, crucial case when it comes to the interaction, the interplay between competition law and the sector regulation. It raises a number of very interesting substantive and procedural points on parallel enforcement, but also on points which were raised before by other speakers about to what extent competition law is complementing or should be read in conjunction with the railway regulation. So, just a few words on the factual background. I mean, the dispute originates from this agreement that took place in Germany between the infrastructure manager and certain railway companies in relation to the infrastructure fees. Litigation, I mean, the case was brought before the regulator and then it went to national courts. It first went, so the claimants initially based their action on German civil law provisions and attacked it directly as a standalone action in the context of private enforcement, and they were asking for the reimbursement of certain fees. Now, that case, CTL Logistics case, preliminary ruling, the court held that national law in this context couldn't apply, as it would frustrate the aims of the directive. Pretty much the same case was then brought under 102. And the other question was, to what extent can the direct effect of 102 be essentially impact the previous ruling in the CTL case? And the court had obviously to go into a delicate balancing exercise between the direct effect and primacy of EU law with Article 102, but also preserve the role of the regulator under the directive and essentially ensure a framework that would be applicable. So it had to balance somehow the scope of the application of competition law in the area. The court started by reminding that under the relevant directive, the role of a regulator is essentially to take all the measures necessary to remedy infringement of the directive, but in the same time that operators have the right to appeal to the regulatory body if they felt that the prices charged by the infrastructure manager were unfair, or they were treated unfairly. The court then went on to make three interesting points which apply across the board of the, so to say, of the market. First of all, by saying that the regulator, when in the mission that's entrusted to him under the directive, essentially also applies competition. That it goes back to the complementarity point to some extent, that the rules of the directive about access fees contribute to ensuring the objectives of Article 102. Obviously, that also meant, to some extent indirectly, that railway undertakings can invoke competition law provisions before the regulator, and that the infrastructure manager must take into account those general objectives when setting the access fees. One interesting point, which has been a lot commented on, is the relationship between the regulator and national courts. The court in this case set a rule which essentially obliged litigants to first seek a remedy with the regulator before going to national courts on a claim based on EU competition law. So indirectly there was a hierarchy introduced from a procedural point of view on how to address this type of disputes. And the court justified this mainly given the technical nature of the industry and certain constraints which were very specific to the railway industry, and underlining also the key role of the regulatory body and in his objective to ensure the non-discriminatory access to the railway infrastructure. It also set this rule about cooperation between the courts and the regulatory bodies. Courts were not bound by the decision of the regulatory bodies, but to some extent they should take into account at least the factual assessment that was made by the regulator. Given timing, I will move on to the specific examples of the specific cases. That's section 2, which concerns the first example is the abuse of dominance case that was brought initially by the European Commission. And it is perhaps the most famous and the most clear-cut 102 abuse that was ever established, given the factual context. Very briefly, the Lithuanian Railways, which were a vertically integrated company managing both a network and also providing services on the market, transport services in Lithuania, they had concluded an agreement with a Polish company to transport in the freight market, to transport the oil. It was an oil company. After a disagreement and a dispute that arose, that company considered reshifting the transfer of its oil through Latvia. That essentially meant that it would no longer use the Lithuanian railway infrastructure, but will redirect it through Latvia and would only use a segment, which was, if my recollection is correct, 19 kilometers in Lithuania to cross the border. The reaction of the Lithuanian Railways was to basically dismantle, destroy their own infrastructure, their own network, which was considered by the European Commission as an abuse of a dominant position. The two conditions here were relatively easily met. Dominant position in both the upstream infrastructure management market and also downstream were established given the legal monopoly that that company enjoyed. And the abuse was essentially the removal of the truck without any objective justification, which in practice here didn't allow that company to switch to another operator, to another competitor of Lithuanian railways. That case reached the General Court. The General Court dismissed the appeal by Lithuanian Railways, upheld the Commission decision, and that case made its way to the Court of Justice, which upheld the judgment of the General Court and, of course, the Commission decision. It's interesting to note that 2 points. First of all, that regulatory obligation to grant access to infrastructure is particularly relevant in the assessment of behavior of an abusive conduct under Article 102 of the treaty. That's one of the main takeaways of the court. And it's also interesting to note that Lithuanian Railways, to justify their behavior, relied on a case law which is famous in the competition world, known as the Bronner case law, which essentially deals with refusal to supply and the condition on which a company, a dominant company, can refuse to supply its customers. And here, the court basically said that you have to distinguish between a type of abuse like the one at stake here, which is the destruction of infrastructure, from a refusal to access in a network, in infrastructure. So it made clear that the deliberate destruction of an infrastructure cannot, sacrificing your own asset, cannot be compared to a refusal to supply, and therefore fits or should be analyzed under a completely different analytical framework to the refusal to supply cases. One interesting element that the court underlined was that here the infrastructure did not belong to Lithuanian Railways. I mean, it was financed by the state. It was a state infrastructure, which therefore made the obligation of the infrastructure manager to grant access on an undiscriminatory basis to other operators even higher. Now, very briefly, I will move on to 2 state aid cases. If I still have 2 minutes. 2 minutes, perfect. I'll try to do it as quickly as possible. And I'll then shift the burden to my colleagues. I'll shift the burden to my colleagues from the Commission then to take the hit on these ones. So, no, I just wanted to briefly mention, as state aid has also been very often used by member states to delay or to somehow block the opening up of the market. I want to mention a recent case, the Arriva Italia case. I'll go very quickly through the facts. Arriva is a subsidiary of Deutsche Bahn, and they wanted to buy a company in Italy which was providing regional services in the Apulia region. And that company was under difficulty, the Italian company, and the state stepped in and provided with some financial facilities that enabled it to stay alive and continue to benefit from the contract that was assigned to it, which was to manage the infrastructure in the region and also to provide railway services. Now, one of the conditions to establish state aid is obviously the distortion of competition. One of the arguments that was brought forward by the Italian government was that here you had essentially no competition on the market because you had a statutory monopoly. And there, the Commission, which basically followed the notice on state aid that's issued by the European Commission, so the court followed that definition, that it's one thing to have competition on the market, and it's different to have competition for the market. So when here essentially the contract was awarded through tender, so Arriva was essentially competing for that tender to get that concession from the state, and that's competition for the market essentially. So as long as you can compete for the market, then there can be a distortion of competition, which is the main difference from the other case which is mentioned, the Scandlines, Germany, Scandlines, Denmark case, where the absence of distortion of competition in the case of a legal monopoly meant that the state aid rules were not applicable or that they were unproblematic. I will pause here. Thank you very much.
Thank you for this rich presentation on the scope of the opening, the relations between competition law and sectorial regulation law, and the relations between national courts and regulatory bodies. Now I turn to Elisabetta Garofalo, who is a legal officer at the European Commission, Stéphane which is a case handler and policy officer, to talk about litigation before the European Commission in our matter.
Yes, thank you very much. I realize that we, the Commission, are the only thing that separates you from a well-deserved evening. So, and it's good. It's a great thing that I personally only have 12 minutes and 30 seconds for my presentation, because infringements, enforcement of EU law, are not something I'm supposed to talk about, because they are a dialogue between the member state and the Commission. It's an exclusive dialogue. But be reassured, there are things I can say, and I will say, because some are in the public domain. So I'll try not to be pathologically short, to paraphrase the judges said the Italian regulatory body had been pathologically long in its decisions. So I cannot talk about litigation when we talk about infringements at our level, at the Commission level. I'd rather talk about enforcement, because we are enforcing, we're like a troop of border collies trying to rally all these dogs that want to go in all different directions, the sheep that want to go in all different directions, and try and push them all in the direction of market opening and compliance with EU law. And unlike a lot of people in this room, we do not like going to court. So most of our procedures never end up in court. So what you have seen now, what their colleagues have presented, is like the tip of a big iceberg. So the tip is things that go to court, and we can then discuss at length, dealing on what the court has said, what it wanted to say, what it means, and the implications. And it's very nice. But then there is the other part of the iceberg, which is all the procedures that take place behind closed doors, our letters of formal notice, our reasoned opinion, that never go to court because the member state get their act together before. And so, unfortunately, you don't have the chance to comment on that. But so in my very brief presentation, because I already used a couple of minutes, I would like to give a broad overviews of the problem areas that we find. I cannot go too much into detail in some cases, but I'll try to make this it's bird's view of what we observe. Well, first of all, what do we enforce? Because I think we have not yet been clear today about what are the legal texts that we enforce. Briefly, it is the rail regulatory framework, the market pillar, so essentially what we call the recast directive, the 2012 directive, which was modified by the fourth railway package. Then we have the technical pillar, so the interoperability and safety directive, what we enforce. And an elephant in the room we have not mentioned at all, which is the PSO regulation, Regulation 1370, which establishes what member states can do when they want to finance public services and compensate public service operators. And our colleagues here, my colleague here, Séverin, and his colleagues in DG Comp, they enforce competition law, which is also embedded in these texts that I have explained. So how do we go about enforcing? And there's two main ways. One is ex officio, and this concerns most specifically the recast directive, because we at some stage the Commission was crazy and said, well, let's look at how this 64-article directive is implemented in 28 member states, or 27 member states. And, and let's do it very systematically. And so we embarked in this huge endeavor to try and find out what the position was in all the member states and what they were doing right, and especially what they were doing wrong. So that's our ex officio work. And then there's complaints. And I find complaints are a lot more efficient because they just zoom in on what is really hampering market opening. We do that as well. We do have complaints. And especially they concern not so much the transposition, because we look at at how member states have transposed European directives. But then one thing is the paper, and then a different thing is the practice. And complaints, they zoom in on how member states apply, and which is why they're so interesting for us, because you touch reality. And for example, for the PSO regulation, which is a regulation, we don't go into conformity check, we rely on complaints to find out what's wrong, what's rotten in the Kingdom of Denmark, and also in all the other kingdoms and republics. So let's move quickly to the substance. So as regards the market pillar, so the directive, basically, the recast directive, we find that one main area which is very problematic concerns not all member states, but some member states, the autonomy, the powers and the resources of the regulatory body. And we are extremely attached to the regulatory bodies because they do our work, basically. They are a first line of defense. A lot of things are sorted out by the regulatory bodies. They say there's the good cops, we in DG Move, because we can only tell the member state to stop what they are doing. Sanctions are rare. Then the bad cops, our colleagues in DG Competition, they can ask for recovery of huge amounts. And then there are the best cops, and the best cops are the regulators, because they sort out so many things for us. So obviously, we have to preserve their powers, their competences, and to ensure that they have sufficient staff and sufficient material resources. Of course, it's very difficult because how long is a piece of string? How many people should a regulatory body have? So we had to focus on very extreme cases. One I can mention because it's in the public domain, Spain. They only had 3 people for a member state that has a lot of high-speed lines, extensive railway network. We thought, well, now this is extreme and we have to look at it. And so we questioned the resources of regulatory body in other cases, but of course it's difficult to have really clear-cut cases such as Spain. And then the autonomy. There, it's really difficult. You can write it on paper. You can have criteria saying, well, you know, they should be independent. They should not be appointed by their mandates, should be so and so on. But then there are some realities on the ground that make some regulatory bodies more afraid of their competent authorities. That's something that we cannot attack legally. It's a question of culture. That's not something that we can. I just want to share it with you and say, well, you know, some regulatory bodies will really have the impression that they're not so independent when we look at their actions. I mean, the regulatory bodies here in the room, they're great. They're the best, and that's why they are here. But those who are not here, and that's why we can hit on them, sometimes we're very surprised about their action, or sometimes lack thereof. So that is a big problem area. And we see it for the market side, but we also see it for the technical side. These national investigating bodies sometimes are not independent. Sometimes they do not exist. Sometimes, like, again, I'm sorry for you, Spain, but we had a big issue with a big railway accident in Spain. And we realized that there were huge shortcomings in the way that safety rules were being implemented, that the investigating bodies was not independent at all. I have another case where they even acknowledged openly that, yes, they had actually an investigating body, but they did not manage to recruit people. And so in the end, the chairman of this body resigned. So they haven't had an investigating body for the past 5-7 years. So this is the kind of cases that we tend to have on this. Then we have problems with member states' acceptance that they have to pay, and the rail is not cheap, rail is very expensive. So in the recast directive, there is an obligation for member states to cover any shortfall in financing of the infrastructure manager. Some member states are really very reluctant to accept that principle. And we see sometimes infrastructure managers with huge debt. In France, for example, sorry, I can't name that because it's in the public domain, where the railway debt to the infrastructure manager was huge. So this is a point that we had to raise because it creates issues. In some member states, there are no contractual agreements. What is a contractual agreement, you will say? It's very, very simple. It's the member state telling the infrastructure manager, I will give you so and so much money over 5 years so that you can do all you have in your nice business plan and you can build and maintain infrastructure. And it's extremely important for an infrastructure manager to know how much money they will be getting. So sometimes it's extremely difficult to get these contractual agreements signed. In Greece, they've been telling us for years that they will sign it. And now, yeah, we're kind of tired of waiting. So then there are other things. Are we successful? I mean, there are other things I could mention a lot on access. It's usually the regulatory bodies that sort out access questions for us. But sometimes there are things that are enshrined in legislation that block the regulatory bodies. For example, priority rules. Who gets the path when a network is congested? In some member states, it's systematically the incumbent. So that cannot be. And so, for example, we opened an investigation, an infringement procedure against Lithuania, because that was the position there. And then we are trying to work it out with them without going further, but not very successfully until now. We hope we can get there. Access to service facilities has proven quite difficult. So that's also a problem area. Are we successful at sorting these problems out? I would say, yes, we are, eventually. So it takes time. However, there are areas where we are not so successful, and that is where the regulatory framework is not good enough. And there, I have to be honest on this, it's sometimes really not good enough, because it's not the Commission that makes the law, it's the co-legislators, and we have big discussions, and in the end, the Council and the Parliament have their own way. And so, for example, a very important and very problematic area is the holding structures, the independence of infrastructure managers that belong to a vertically integrated undertaking that is owned by the state. This creates a lot of conflicts of interest which are inherent. I mean, I am the member state, I own a big company, I have the infrastructure manager and the operator, I want the operator to thrive. That's a huge conflict of interest. So I have to exercise a lot of restraint as a member state if I want this to work and not to have a discrimination. An infrastructure manager that belongs to a larger group is vertically integrated. Of course, there is a huge potential for discrimination and for discriminative treatment. We have rules, but I have to admit that they're weak. So these are the areas where, unfortunately, we don't manage always to get our way. And so there's still a lot to be done. And just to conclude my intervention, it's not enough to have the rules, they have to be good. And in the end, you cannot ram liberalization down member state throats. They have to be willing. They have to be willing to embrace it.
So I'm the last one, so I will try to be short. Thank you very much for the invitation. So yes, indeed, we are the bad cops, but we are not that many bad cops. So basically, yes, we have a small presentation. There will be 3 parts, just a panorama of the issues, the legal basis, and the redress mechanisms. Then we talk about the 2 main pillars of competition policy. I leave out merger control because I think it's not specific here. So antitrust and state aid. And then I will just try to describe what is litigation, I mean, basically complaint handling in our service. Alors, voilà, framework of competition policy. I try simplified, trying to see what are the infringements in red, in blue the instruments, and in green the enforcement bodies. I still put regulatory rules here because we have, especially in state aid, we have to take into account a possible infringement of regulatory rules. You would have the Hinckley Point judgments recalling that if there's an infringement of regulatory rules, we cannot declare a net incompatible. So that's, of course, very powerful to ensure compliance with sectoral rules. So for antitrust 101, 102, the rules on sectoral rules, I will not repeat what Elisa said. And for state aid, we have basically two main instruments. The first one are the state aid railway guidelines, which rely on Article 93 and 107 of the treaty. We have the PSO regulation. It is a weird animal, the so-called elephant in the room, which is of shared competence. So basically, DG Move is in charge of many aspects of it. We are dealing with fewer aspects, but still important ones. I also wanted to talk about the Sleeping Beauty, because you all talked about transparency, and we have this directive from DG Com, the only one on transparency from 2006. So this is the 2006/111 regulation on financial transparency, and this one in the future may be increasingly used. So important for the regulators, also for the vertically integrated companies. In terms of enforcement bodies, so yes, we know at Commission level who is responsible, but again, as I mentioned earlier, we have also at national level very powerful and necessary enforcers with whom we are actively working with. So national competition authorities as regards 101 and 102, national regulators for DG Move, but also in our case, the judges. It's very important just not to underestimate the power of getting redress with national courts. They're not aware of their powers, but actually they have powers, and in terms of complaint, they are under the duty to handle those actions lodged by competitors. And I put regulators in question mark because Article 56 of the Recast Directive, ask the railway regulators to actually to raise certain matters. And as I discussed earlier, Article 6 to 8 of the Recast Directive actually are very similar to state control because, in principle, somebody should check the absence of cross-subsidization, should check that the infrastructure manager is properly financed over 5 years, should check that within vertically integrated company, the loans are done at market terms. And, and again, there's a great potential to use those provisions in the Recast Directive. Antitrust infringement, my colleagues mentioned, yes, so that concerns the left column. And as Article 101 concerns, with agreements between undertaking and the two most typical examples of anti-competitive practices are bid rigging and customer allocation and price fixing. And these, of course, can be addressed either in the Commission or at the level of the national competent authorities. Then you have Article 102, which is abuse of dominant position. And here I've just taken 3 examples. So we mentioned the famous Lithuanian decision. The predatory pricing, we issued recently a statement of objection against the Czech incumbent, České dráhy. And we have the issues of giving access to infrastructure, facilities, or supply. So voilà, that was a famous example. I think there's a real picture of the Lithuanian problem. And you have the map of what Alfredos described. Voilà. So you see that the 19 kilometers are the red bits where the tracks were dismantled. and forcing, you see, the competitor to use the blue journey. Stated infringements. This is my bit, that's why maybe I'm a bit longer. Alors, here I've tried to map basic public support measures. Usually they concern the incumbents. Alors, first you have a first series of end measures which are aid to infrastructure, and each of it can raise set issues. Of course, for the owner, for the operator of the infrastructure, and for the user. Then you have a second group of measures which are maybe problematic, of course, are intra-group financial flows. And then you have the issue of transparency. I mentioned the directive before. You have also what we call the notion of end notice, requiring, the separation of accounts and the absence, of course, then of cross-subsidization. State financing, usually of the incumbent at the level of the holding. So you have capital injections, debt reliefs, public guarantees, or restructuring measures. We have, a series of decisions. I will not list them today. They are available on our website, and of course, I'm available to provide them if necessary. Then, very important, we'll talk about it in a minute, the monitoring of public service compensation. Other operating aid, like track access charges. At the moment, with model shift, there are many schemes being adopted to reduce the cost of the railway undertakings, including for passengers. So you have now proposals for the night trains to reduce, or even for COVID. There was also a means to channel a lot of public money to this railway undertaking, single wagon load, and intermodality. And there's also investment aid for railway undertakings, and we have many measures concerning the financing of rolling stock, interoperability like ERTMS, or the construction of service facilities. But now, for the measure to the right, of course, those measures now are being made available to the new entrants. Voilà, so that was a bit of a mapping. So what, for 1370, so the PSO regulation, we have basically two issues. The first one is the correct definition of PSOs, and what we mentioned here is the famous SNCM test. And why it is important? Because with market opening, you will have an interplay between open access services, which are now the norm by default, and public service, which now is the exception. Before, that was the contrary, and this is important. So how to basically organize the right interplay between the two. So the General Court, in its landmark judgment of 2017, has defined these tests, where basically it's a three-step test, where the General Court said that in order to avoid a manifest error in the definition of the PSOs, the member states or the competent authority should first define if there is a real demand. The second step is to basically check there is no market failure by checking if there was no commercial offer already available on the market. And the third one was to say, please always go for the least distortive measure. And in the maritime sector, so not applicable here, the choice was between general public service obligations imposed to all operators or the choice of a public service contract. And General Court, relying on the Annamayer judgment, basically recall that you should always go for the least distortive measure. And of course, this issue will be even more problematic in the future because you have large-scale public service contracts where you have now competitors competing on some of those lines. And of course, this overlap is problematic in terms of state aid. The second aspect, of course, of our check is overcompensation. The regulation here, 1370, is not very clear about, what kinds of parameters are eligible to the compensation. Also, the way the allocation should be, costs and revenues should be allocated between the PSO services and open access services, because you can imagine a train that is commercial on the backbone, on a high-speed line, but continuing further under a PSO contract. And then how would you allocate costs and revenues between the two? That will be, in the future, an increasing problem. And of course, then you have the issue of the level of reasonable profit. Other stated issue, of course, cross-subsidization, excessive investment aid, unjustified operating aid, and many other of the issues that I tried to map in the previous slide. Now, how to basically concretely handle complaints. So basically, I've tried to describe in a very simple manner how we receive and handle complaints. So instead, now you have to use a mandatory complaint form. Why is it so? Because we used to have so many complaints that we had to increase the bar to have really well-substantiated complaints. And now we are allowed to reject those complaints. We are just 22 officials, for all stated in transport, so covering maritime, railway, but also aviation. So we have to focus on the real important ones. And step 2, collection of information. So we send letters to companies in antitrust and to member states in state aid, or also to the complainants. And of course, it's well known for antitrust, you have this on-site inspection called downgrade. In principle, instead, we have this possibility under the procedural regulation, but of course, politically, the Commission never dared investigating ministers in there physically. Step 3, then we carry out our preliminary assessment. Basically, we collect and analyze all the data and input received from different stakeholders, and then we have basically 2 options. Either we say, oh, this complaint is not well grounded, so we reject it. Otherwise, we take a formal decision where we approve the aid, or we open the formal investigation. I'll come to that in a minute. And in antitrust, it's more or less the same, the main procedure, with, I would say, more possibilities to actually find settlements and to close the matter in a more expedient manner. Alors, formal litigations, of course, these are the most touchy cases. These concern very few cases in percentages, I mean less than 3%. But of course, they can lead to very negative and adverse outcome if the Commission comes to the conclusion that, for example, in state aid, the aid is deemed incompatible. We have in the railway sector opened recently many investigations in the freight sector against Trenitalia 8 years ago, against DB Cargo last year, and to Fret SNCF last month. And these, of course, we are talking about billions of euros, so you can understand the political sensitivity of those cases. But we cannot exclude that in the future, we may have the same issue for passengers. That's why we try to deter and to avoid, to have those complaints in the future, and prefer to raise the importance of having a well-designed state aid. And in antitrust, you have also the prohibitions leading to fines, and or you can have a commitment where you find a solution where the company subjects to the investigation needs to take some actions to change and or put an end to its anti-competitive behavior. Voilà.
Thank you for these 2 very interesting presentations with a cross-sectional view overlooking national realities in their positive or perhaps insufficient aspects, and the procedure with the Commission. So, have you questions, dear colleague? Wait, I know. It's question. It's question.
I have two very specific questions. One, state aid guidelines. When? I mean, it's something that we are waiting for, and I expected some reference or maybe a couple of words on the new version of the guidelines. And another one, if you can elaborate a little bit more on this excessive pricing in track access charges, because it puzzles me. If track access charges are covering direct costs, but I've never seen total costs, how could you reach to an excessive pricing decision? I mean, what is the approach to apply excessive price? To you? Yeah, Alexander, you made a reference to excessive pricing in track. I don't know if I got it wrong, but it puzzled me, this excessive pricing where you are not covering total costs.
I will then leave the floor to my colleagues Now about the advocacy studies. Means no,
I think it was
for you.
Yeah.
No, I think it was in the context of the DB station case, if not mistaken. It was that was the legal basis, if I'm not mistaken, in a domestic litigation before the case reached the court, when the railway operators went to contest the infrastructure charges. That's what they claimed. Under domestic law, they claimed the price was unfair. Not in relation, not on the basis of the directive, not on the basis of the specific regulation of that applies to the railway sector, but rather under German civil law. And essentially, when they brought the claim afterwards under 102, that was the concept they were using to attack essentially the prices, to ask for the reimbursement of the fees paid. I mean, it raises a wider question about the complementary nature of competition rules. Article 102 is a very specific example and goes back to discussions also earlier this morning. And obviously, when you look at Article 102, excessive pricing from a competition law perspective, the test or the exercise is different from the one I suspect a regulator would do, right? Because when you look at 102, in a pure competition law context, what you're looking at is whether your price is excessive when you compare it to a benchmark that renders you find a price which is fair. I'm oversimplifying. So you can have a theoretically situation where under competition law, a price imposed by infrastructure manager is excessive or maybe unfair, and I'm underlining theoretically. And at the same time, you can have a regulator which considers that price to be correct and legit based on the objectives that pricing completes for the specific railway regulation. So if, for example, and I'm not an expert in the area, but if, for example, the pricing of infrastructure manager has as an objective to maintain the infrastructure, or has to finance works on the infrastructure, then you can argue that a higher price is justified. That same reasoning, if you were to analyze it purely under competition law, may not be the same, because in that case you may find a reason for excessive pricing. I think that was the reference. It was not in the context of the decision of the court, of the judgment of the court itself.
If my memory serves me well, I think it was about station charges. Station charges, and so it's not the same as track access charges. And so if I remember correctly, we did not have at the time of the facts of the case such a precise regulation for charges in service facilities. So I think there was more the possibility of an exercise of abuse of dominant position by DB station, which perhaps would not be possible in the same way with the new directive. So, yeah.
As regards the railway guidelines, it probably would be more to 2024 than 2023. But in any case, before the end of the current commission.
Et donner la parole à notre excellent collègue Stéphane de la Rosa, qui est professeur à Paris-Est Créteil, et qui a la tâche complexe de faire des remarques aussi conclusives que synthétiques. Je l'en remercie d'avance.
Merci, chers collègues. Quelques mots en français pour entamer ces conclusions et remercier très sincèrement et très chaleureusement Aurore Laget-Annamayer, l'équipe du CR2D, la chaire gouvernance et régulation, de m'avoir convié ici à prononcer quelques mots conclusifs. On avait déjà eu un premier opus de cette question de la réflexion sur l'ouverture à la concurrence du transport ferroviaire à Rouen, et nous voici désormais dans ces beaux bâtiments de l'université de Dauphine, bâtiments qui, rappelons-le, furent le siège jusqu'en 1966 de l'OTAN, peut-être un signe précurseur de la bataille feutrée du rail que nous avons aujourd'hui étudiée et de la nécessité d'avoir des régulateurs. Alors, le symbole choisi par Aurore Laget pour illustrer ce colloque est le tableau d'Henri Hotman, peignant en 1903 la gare du Luxembourg à Bruxelles, aujourd'hui souterraine. symbole de révolution industrielle, de voyage. Bien, ces trains furent aussi décrits presque à la même époque par d'illustres auteurs, Marcel Proust, dans La recherche du temps perdu. Je ne pouvais, sans que mon cœur palpitât, lire dans les annonces de la Compagnie des chemins de fer de l'Ouest les annonces de voyage. Elles m'invitaient à parcourir les pays et l'Europe, mais au-delà, elles ouvraient un indescriptible voyage intérieur. Revenons en 2023 et aux voyages qui ne sont pas intérieurs mais juridiques et économiques, auxquels justement nous convie l'ouverture à la concurrence du rail. Cette ouverture est porteuse de nombreuses promesses et qui furent rappelées ce matin par Éric Brosseau et Claudie Boiteau. Stimuler le marché, la compétitivité ferroviaire par un accroissement ordonné de l'offre de transport, promouvoir une concurrence par la différenciation, par la qualité, en cohérence avec les modèles que nous connaissons d'oligopole, de duopole, Stackelberg, Bertrand, saisir la concurrence pour améliorer la performance des réseaux, l'attractivité, et j'ajouterai également saisir la concurrence pour faire du ferroviaire le mode de transport majeur pour réaliser la transition écologique et tenir les objectifs du Green Deal européen qui prévoit une neutralité carbone en 2050. Mais ces objectifs, aussi louables soient-ils, renvoient, on l'a vu, à des réalités très hétérogènes selon les États. Et le mérite de cette journée est précisément d'avoir mis en lumière cette diversité et ses limites. So now let me switch to English in order to highlight the two main core ideas of this day. Firstly, this idea of the legal diversity of the past for opening up to competition, and secondly, maybe some thinking about new grounds for considering the evolution of the legal framework. So on this issue of the legal diversity, a complex but also fascinating issue did arise from our initial discussion is this discrepancy, the gap between a common legal pattern, which has been laid down in EU directive from the first to the fourth package directive, and on the other hand, a significant legal diversity of practice, of regulation, of law in the way to implement this common legal background and this legal pattern. This discrepancy has strong legal foundation and also many practical consequences in the regulation of the rail market. The point has been stressed this morning in the discussion with the Commission, but it also be pointed out this afternoon with the Italian regulation authority. In the field of rail regulation, we have to consider incomplete harmonization from EU legal law. And I would add incomplete and imprecise harmonization from EU legal law. And this incomplete or imprecise regulation is the consequence of the negotiation of the text, of the position of the member state, of the main railway company, and we can stress on maybe 3 or 4 examples of such discrepancy between the text and the implementation. The first idea is about the criteria that underline the calculation of the charges, the rail toll, le péage ferroviaire, the charges. It has been recalled this morning that the cost is directly incurred as a result of operating of the train services. That's a very wide formula, and it gives a real leeway to manager infrastructure to add, to define market segments in order to precise this broad formula for the calculation of the charges. So we had the case of Spain, where we had the example of different tariffication with the corridor strategy for Spain within the north and the south, or the optimized regulator between Madrid and Barcelona with the tariffication, and also including whether we are a new incumbent or a mix with competitive and new incumbent or low-cost model. We have on the other side the case of the French authority. Olivier Salès told this morning that now the national authority assumes the Ramsey-Boiteux model for the tariffication of the monopoly. in order to have a charge which has to be sustainable, in soutenabilité, de redevance de marché. We have the case of Austria with a mix between tarification with cost and specific PSO tarification for the charges. So a huge leeway of practice and a huge leeway that had been recognized by the Court of Justice in a case which has been recalled by Stéphane Rodrigues of 9 September 2021 as La Traille Net, where the court did clearly insist on this leeway and on this margin of appreciation. And in my opinion, such a leeway maybe is a further ground for a form of battle, of legal battle about charges in many member states on the type of calculation and the type of criteria entering into the calculation. Another example of such discrepancy is maybe the form of access to the network. We have also this broad formula in the directive saying that there is a right of non-discriminatory, transparent and fair access to the market. But beyond this formula, we can observe also very huge diversity of practice. We had the franchisee system, yes, in the UK, the système de Francie, the franchisee system in the UK, which has been portrayed a decade ago as a model for opening up to competition in continental Europe. But as it has been rightly said, this model now is really criticized. There are important changes which are now considered. And it has been said that maybe over-specification, over-detailed specification for franchising operator are a constraint in order to open up the market. We have another model, which is the Spanish model, but which is very specific and maybe not duplicating to other countries due to the geographical organization of Spain, of competing capacity with framework agreement, with 10 years asymmetric framework agreement, 6 main incumbents. Very interesting model because we didn't have legal challenge or legal disputes about this mechanism, but maybe he has his own justification regarding the low utilization of the network and maybe also the need to finance a quite recent infrastructure in Spain on the whole territory. And we have also the more, I would say, classical model of access of network. I speak only about open access, with a classical path contract, en français un contrat de sillon, path contract, that we can observe in France or we can observe in Italy, which is a more classical, complex but classical contract, which is, I would say, a classical, maybe mechanical implementation of the directive. And last point of this diversity on the charges, on the access, maybe also on the powers and the duties of the regulatory authority. It has been recalled that the directive, Article 55 of the directive, says that member states shall establish a single national regulatory body for railway sector. It shall be independent in its organization, funding decision, legal structure, and decision making. And we have a list of functions in the directive that has to be assumed by the regulatory authority. But again, these provisions are very wide, very general in their wording, and therefore we can observe also a huge diversity of practice, and the exchange of this morning and this afternoon also shed a light on such diversity. The diversity can be observed first about this articulation between the competence of the regulatory authority applying sectoral law and the application of competition law. You had a very insightful debate on that point this afternoon. On this topic, I just want to recall that a long time ago, quite a long time ago, the Court of Justice, in the famous case Nouvelles Frontières, 1985, said that the existence of specific sectoral provision about transport policy does not preclude from the application of general rules on competition, especially Article 101, 102 of the treaty. Nouvelle Frontière was a case about airplane markets and opening out to competition for airplane. But Nouvelle Frontière is obviously relevant for rail markets and for admitting that we have a coexistence of sectoral law and classical competition law. But this coexistence of sectoral law and classical law is not a hierarchical relation. It's not a hierarchical relation. They are in the same level playing field, because they do fulfill two different finality, two different objectives. The sectoral regulation that it is laid down in the directive is more a structural law of competition, of type of access, in order to maintain the smooth organization of the railway market. Instead of the provisions on competition policy, 101, 102, are more about the behavior of actors within the market. It's a form of police of the market in order to not disturb by specific behavior the functioning of the market. And we had yet topical cases on that point. We had this case of Ledvius. We have the case of the Court of Justice of 12 January 2013 in Lithuania, where the court ruled, it has been said, that the fact to remove a tract is obviously an abuse of dominant position. And we have this very interesting case, DB Station. Maybe 4 or 5 of you spoke about the case DB Station of 27 October 2022, case C72120, in which the Court of Justice say that it is possible for a national court to apply at the same time sectoral law and Article 102, abuse of dominant position, in order to appraise the lawfulness of the charges. But, this but is very interesting, there is a duty of sincere cooperation, un principe de coopération loyale, between the judge applying Article 102 and the regulator. And the regulator, once the regulator has smoothly applied the sectoral rules. That means that for the CJ, there is a need to bring together the classical application of general competition law and, through the regulator, the application of sectoral law in the field of regulation. So, obviously, a huge, impressive diversity of rule of practice, because we have impressive text. But maybe if we consider a more dynamic approach, we can consider maybe new paths, new grounds for making an evolution or changes or new way of interpretation for the legal framework. And on this evolution, or maybe just idea to share on the evolution of the framework, I would like to stress on 3 main ideas. The first is about the articulation between PSO and non-PSO line. I feel that the PSO sometimes had been the forgotten piece of our debate today. We have mainly focused on the access through open access, classically on the ground of Directive 2012-24. But we have to bear in mind, we have to keep in mind that in many member states, PSO regulation has a significant scope. In the case of France, 72% of the network is under PSO regulation. We have also cases of national PSO lines. This is the case in Austria, Salzburg, Vienna. This is the case in France with the train d'équilibre de territoire between different cities, for instance, Nantes, Lyon, or Bordeaux, Marseille, Toulouse. That's TOT. We have also countries where almost all the network is under PSO, like Belgium, like the Netherlands. So we need really to consider, not only to focus on open access, but to consider a proper articulation between open access and PSO. And regarding that point, my opinion, and it's just an opinion I would like to share, is maybe also the idea of a conclusion, maybe we could consider an evolution of the concept of PSO as itself. Because in the current case law, PSO or PSO is not only a matter of free regulation. We can also find PSO in the market energy, or we can also find PSO in the directive on telecommunication. It's a broader concept, PSO, in EU secondary law. And PSO is defined as an obligation that should not be assumed by an undertaking if such undertaking should only seek its own interest. PSO is only seen through the concept of failure of market failure. But in the current time, we speak a lot politically of PSO in order to fund network or remember to use PSO for the green transition. And I wonder whether such conception of PSO is still relevant in order to the new tendency of transportation and the new orientation of rail. So maybe, and it's just a ground for discussion, we could also consider in the future award of PSO also for open access with a compensation, but not on the ground of a contract like in the regulation, but on the ground of an exclusive right and through the procedure of an exclusive right on the ground using the inspiration of Article 106, paragraph 2 of the TFU. It's a legal proposal, but we shall consider that point in my opinion. The second point of evolution is about state aid. So really, and we have a presentation at the end with the member of the Commission, the landscape of state aid is really changing. And it's really changing for two main reasons. Firstly, because we have a relaxing application of the classical framework of state aid. This relaxing application has begun with the COVID crisis, but more generally, I would say the legal rationale of state aid has also evolved with main tools such as the regulation on facility and resilience. All these tools of the new economic governance about subvention, loans to member states in a new market condition in the context of the Green Deal. We have a new landscape about state aid law. And whether such landscape could be used, could be considered in the field of rail. And apart this new legal framework, there is also this question of new guidelines on state. I had the same interrogation than Juan Montero about the date of the new guidelines. We have a proposal of a council regulation of 6 July 2022 for the application of Article 93, 107, 108 TFU about state aid, in which the Commission proposed to relax the obligation of notification. And in the considerant of the proposal, it is said, or no, in the impact assessment of this proposal, it is said that maybe we could have a form of block regulation, of general block regulation for state aid that could be the same or could be inspired of the GBER. So that may be an important turn and legal change, but also it could be also a ground of challenging, because if we see what we saw, if we observe what we saw in the field of, for instance, of airplane, we yet have a lot of issue and legal dispute about state aid to historical operator in the field of COVID, and yet current issue with Ryanair and so on, challenging the aid which has been given to the historical operator. And also a general block on regulation would also stress on the need to have a proper regulator or a proper national authority to make the link between a form of general block exemption regulation on rail and how to implement the general criteria on state aid rules. Very last point of new tendency is about the execution and the implementation of competition. Apart the case of Italy, and we saw the case with Italo, the admission of new operator is quite recent, is really recent. We have Trenitalia between Paris and Lyon for now 1 year, 1 year and a half. We go Italo in Spain is really also recent. So we lack of time to have a real vision of the concrete implementation of a new operator in market, and we lack insight for a proper appraisal of such implementation. But nevertheless, new issues might be coming in the future. Reporter Ronaldo talks this morning about the price of energy and the consequence of electricity charges and the price of charges, and how to integrate the increase of energy in the charges. That stress on the need maybe to consider more flexibilities with regarding agreement between operator and manager infrastructure, especially for long-term framework agreements. But maybe we still lack of legal tool to consider such flexibility. In the current version of the directive, we do not have sufficient clear tools to modify, extend, change the execution of such agreements. And it is clearly linked to another case we have here in France, and we can make a link quite interesting. Last September, in September, the Conseil d'État gave an opinion, an avis, on the increase of price, saying that we could use the imprevision theory, the theory de l'imprévision, in order to consider that we can admit modification of the contract for imprévision because there is an enforceable and external event that dispute the economy of the contract. I'm not pleading for the extension of the French vision of imprévision, but I'm just saying that maybe we have to consider new legal grounds for long-term contract, because at the current stage, legal secondary law, EU legal secondary law, is not sufficiently designed to tackle such issue. So really now to conclude, and this is the last word, we saw that all these issues of competition brings new challenges, new tendency, new paths of reflection. And I would end in French, because I began in French. J'ai commencé effectivement en citant Marcel Proust. Finissons avec cette formule célèbre de Giraudoux, la guerre de Troie n'aura pas lieu, toujours une métaphore un peu, pas forcément guerrière, mais du moins d'intensité, qui nous dit effectivement, le droit est la puissante des écoles de l'imagination, jamais poète n'a interprété la nature aussi librement qu'un juriste la réalité. Eh bien, puisse cette journée, chers collègues, mesdames et messieurs, contribuer à interpréter librement, avec imagination, toute cette diversité du droit ferroviaire en Europe et dans les États membres. Je vous remercie.
Merci, chers collègues. All good things must come to an end, alas. Claudie Boiteau had to leave us because of an administrative meeting. It's my task, agreeable task, to thank you very much, all the speakers. We had real fertile and rich exchanges, and I hope we'll have more. And I want to again thank you in the name of the members of the Centers of Law Research of Dauphine for having participating in this very, very interesting conference. So, see you again.
Attendez, je voudrais juste dire un mot pour conclure avant que tout le monde s'en aille. Après Antoine, en français d'abord et en anglais après, puisqu'on a tous fait un peu cela, pour vous dire combien je suis heureuse du déroulement de cette journée, qui va même au-delà de mes attentes, qui confirme un certain nombre d'intuitions que nous avions eues et que Stéphane a parfaitement su mettre en valeur. Et really a special thanks to you, my dear friend and colleague Stéphane, for these insightful remarks for the conclusion and the lines you have drawn for the future. I think it's perfect to open new discussion on new issues of the railway sector for our next conference. So after the second conference, I will be delighted to see you in the next one to continue our reflection on the railway sector whenever it takes place. I don't know when, but I hope it will be sooner. Et encore merci à vous et bon retour.